Trial resumed. Jury not present.
The court said, "Good morning. Please make your appearances."
Ms. Murray said, "Good morning, Your Honor." Juliana Murray, Ryan Finkel, Micah Ferguson, and Justin Horton on behalf of the United States. We're joined by paralegal specialist Isabel Loftus.
Ms. Shrofa said, "Good morning, Your Honor. On behalf of Mr. Gwa, Sabrina Shroff, Mr. Kamraju, Mr. Skirik, and Mr. Barkin. And of course Mr. Gwa is seated next to me."
The court said, "Please be seated." Yesterday, defense counsel objected to the government's questioning of Haitham Khaled about the truthfulness of statements made by Ana Izquierdo and Limari Reyes Molinares during a G-Club's arbitration proceeding. The defense argues that Mr. Khaled's testimony would violate Federal Rule of Evidence 608B, which prohibits the use of extrinsic evidence to prove specific instances of a witness's conduct in order to attack or support the witness's character for truthfulness. Specifically, the defense argues that Mr. Khaled's testimony as to whether Izquierdo's and Molinares' statements were truthful would be inadmissible extrinsic evidence of specific instances of dishonest acts. Where testimony is probative only of a witness's general character for truthfulness, it is inadmissible under Rule 608B. United States v. Atherton, 936 F.2d 728, 734, 2dr 1991. United States v. Abel, 469 U.S. 45, 51, 1984. Here, the government does not offer Mr. Khaled's testimony solely for the purpose of attacking the character of Ms. Izquierdo and Ms. Reyes Molinares. The government offers his testimony about the truthfulness of their statements as evidence that G-Club's agents misrepresented facts in the arbitration in furtherance of the RICO enterprise. Accordingly, the objection is overruled. Are there any other issues that you'd like to raise?
Mr. Finkel said, "So, Your Honor, I think there are a menu of items for this morning."
The court said, "Okay."
Mr. Finkel said, "If it suits Your Honor, I think we could start with schedule."
The court said, "All right. If you could just hang on for a moment."
Pause.
The court said, "Go ahead."
Mr. Finkel said, "Thank you, Your Honor." So the parties have conferred. And it's the government's understanding that the defense does not object to a 30 to 45-minute extension of trial day next week. The government has given careful thought to how many witnesses it has left in its case, including considering streamlining it significantly, very significantly. Actually, and also giving thought to what the court told the jury, which is that this trial will be over effectively by July 12th, all in, deliberations, the whole thing. Given the pace of things and sort of where we are, as we've mentioned, we're behind. The lengths of crosses, the lengths of directs in some cases, and just generally some logistical issues with technology, etc. The government's view is that if it's acceptable to Your Honor, and of course the jury, and that, of course, is going to carry the day at the end of the day, the government requests that the court sit a full day next week to whatever Your Honor's full day would be, whether that's 4 or 4:30. This will enable the parties and the court, and most importantly the jury, to catch up in the sense of filling the time that we're going to lose on that Wednesday. Plus, there are additional days off that are plugged into the schedule, which is what it is, and allow us to sort of get back on track. The defense has a defense case. We know that. They have, as I understand it, at least 3 experts, a summary witness, or, 2 experts, a summary witness, and somewhere between 3 to 5 fact witnesses, and then, of course, the defendant could choose to testify about the issues in this case. And whether he does or doesn't is not a question we have to resolve today. But we can think about the logistical implications of his decision to testify if he so chooses, which will obviously extend matters. Then there is the 2 days. I see Your Honor is about to speak.
The court said yes. So are you suggesting that next week one of the days be a full day, or all of the days be a full day?
Mr. Finkel said, The government's proposal, Your Honor, is, in order to catch up and also account for the Wednesday off and future days off and the length of the defense case, is that we sit a full week next week during the 4 days, so we go to 4 or 4:30, or whatever Your Honor normally does on a full-day trial schedule. This will enable the government to catch up and get back on track and land the plane, as they say.
The court said, "Is there something else you wanted to add?"
Mr. Finkel said, "Not on schedule. There are other issues. I don't know if you want to."
The court said, "I'll hear from the defense regarding the schedule."
Mr. Kamraju said, "Thank you, Your Honor." As Mr. Finkel mentioned, the defense did agree to extend the schedule by 30 to 45 minutes because that's what we understood the government, after its careful review and considered analysis of its witnesses, had requested from the court initially.
The court said, "If you would speak louder or speak closer to the microphone."
Mr. Kamraju said, "Sorry." Thank you, Ms. Shroff. So we had agreed to that based on our understanding that that was what would be required for the government to catch up. From our perspective, one of the difficulties that comes from having a full trial day is that every week of this trial now, the government's witness list has shifted dramatically from day to day. Midweek and sometimes the day before witnesses are anticipated to testify. And so for as long as that continues, it's difficult to see how we can address, and, frankly, even take into account Your Honor's suggestions about how we can shorten our crosses if we don't have time to prepare for them and if the government extends it to a full day every week. So I would ask what has changed, frankly, in the government's analysis. Because it cannot all be simply due to their anticipation of the estimated length of cross, Your Honor. Their suggestion is that we're days behind. We've looked at the cross-examinations. They are frequently around the same time as the direct or less. We understand Your Honor's direction to us to cut out the repetitive questions. And we will do that and work on our best on that. But this idea that we, the defense, should be prejudiced in terms of our preparation given the government's continuous shifting of its witnesses. When the government controls its schedule, the government controls which witnesses it wants to call. And the government, frankly, even controls the issues that need to be addressed. I'll just give Your Honor one example of that. I anticipate later today we are going to have the same witness testify again as a summary witness, Ms. Espinoza. She testified last week, I believe it was, or the week before. We're then going to have another summary witness testify at the end of trial. I don't know about what, but it appears to be about very similar topics. Similarly, Mr. Skirik can address it in a little more detail when it comes up. We raised the 701 issue with the government on one of their witnesses. That very possibly could testify today, on Monday. We heard back at 10:30 last night that the government intended to file a letter about the issue. We still haven't seen the letter. I believe they conferred this morning. These are all things that could be avoided and are dragging into the schedule that have nothing to do with the cross-examination. And I understand we are where we are, Your Honor, but we do have to balance the two things. And so from our perspective, the 30 to 45 minutes that the government had asked for, that makes sense. And if they have difficulty in terms of keeping their commitment, they can streamline their case. They don't need to call 3 summary witnesses to talk about the same thing. They don't need to call 14 victims to talk about the same thing. So they too can control the schedule, Your Honor.
The court said, "Were you anticipating 14 victims?"
Mr. Kamraju said, "That's what they noticed to us, Your Honor. I believe it was 14.
Mr. Finkel said, "No. The direct answer to Your Honor's question is no. And as I mentioned at the outset of my remarks, the government is considering significant streamlining of its case. And if I can just respond to a few things that defense counsel said. First of all, yesterday we had I think, productive conversation in which the government explained that 30 to 45 minutes is not going to be sufficient. And so defense counsel knew that the government was contemplating a full week of trial time for next week. That's number one. Number two. The summary witness, who is going to testify today, and the summary witness, who will testify hopefully next week, depending on the schedule, are talking about discrete monetary transactions. And the government is going to show through those summary witnesses how fraud proceeds were used to purchase Lamborghinis, Ferraris, the Mawa mansion, personal effects. As Your Honor knows from prior briefing, there are something around 500 bank accounts and probably 1,000 some odd transactions. That takes time to explain and get in, but we are streamlining it. In terms of victims, I think we have one that should testify today, if we get there, and then there's probably one more. Maybe one after that, but probably just one more. To respond directly to some of the points that defense counsel raised. In every trial there are logistical issues that require some rejiggering of the witnesses for the week. What has happened at this trial is Mr. Khaled, for example, was noticed to testify during the first full week of trial. That didn't happen because the cross went so long. We then were in a problem where we had a witness who was flying in from a foreign country and was only going to be here for a week. And we had other travel issues with respect to other witnesses. Mr. Khaled, as it happens, is relatively local and we have control over his schedule, so we had to move him, okay? There was another witness who was traveling from Europe over the weekend, Saturday morning. We were planning to call him first thing on Monday. After we met with him, we decided, you know what? We want to streamline our case. We don't really need him. So we took him out, which we thought would help matters, but had to replace him in the schedule to accommodate scheduling of other witnesses, including a witness who will probably be called on Friday, but lives in Puerto Rico and won't be here until today. So we had to put a new witness in. These are things that happen all the time. What has also happened, Your Honor, is, with respect to cross, I believe that the cross-examination of Ms. Lee at the very end of the cross, there was an objection from the government about a series of questions that resulted in a sidebar. The sidebar lasted somewhere around 10-15 minutes. There was an argument of some kind. Your Honor overruled our objection. We then resumed the testimony and defense counsel said, "No further questions," and didn't even ask the question that was the subject of the sidebar. I'm not sure why that sidebar needed to happen if our objection was for a question, on a question that defense counsel didn't even intend to ask. Yesterday, during Mr. Khaled's cross-examination, we spent 15 to 20 minutes on whether Victor Serta was emailed an opportunity to join Crane Advisory Group. I don't know why that's relevant to either his credibility or to Mr. Gua's involvement in the RICO enterprise. But that's fine. They're allowed to cross-examine the witnesses. The bottom line is this, and this is the way the government is looking at this. Your Honor told the jury this trial will be done by July 12th. I predicted wrongly. Your Honor was right, that we would be on track to finish by July 4th. I don't think that's going to be the case anymore, and I'm glad Your Honor had the wisdom that I did not. But to get us done by July 12th, we cannot do, we need additional time. And what we propose is a full week of the 4 days, with Wednesday off. It will enable the jury to catch up in their lives to the extent they need to. This is not an imposition. We're all on trial. I think we all want to move this trial efficiently forward. We will certainly work with the defense in any way we can to communicate with them, to advise them of who our witnesses are going to be when changes are necessary. Sometimes things happen, when exhibits change. We're doing all we can to be efficient. But a 30 to 45 minute extension candidly, is not enough. And we are considering, just so Your Honor knows, cutting witnesses. The government is considering cutting witnesses that I'm surprised that we're even thinking about it. But we are thinking about it to streamline the case and, as I said, to land the plane and meet the deadlines and the end date that Your Honor outlined to the jury. But even with those cuts, if we just sit an additional 30 to 45 minutes next week, we're going to end up in late July. Given the length of the defense case, given some witnesses that we have to put on to prove our case, there are a lot of charges here. It's a complicated scheme. We have a burden that we have to meet. And so we'd ask Your Honor to please ask the jury if it's okay with them to sit a full day Monday, Tuesday, Thursday, Friday next week.
The court said, "I'll think about it."
Mr. Khamraju said, "I just wanted to respond with one clarification, Your Honor. I believe Mr. Finkel talked about a sidebar at the end of Ms. Lee's testimony. I think that was on the translation issue, not on a government objection. He also discussed the travel issues that prompted the government's original request. I believe, to extend the time of the trial. We accommodated those travel issues, and not only did both victims, excuse me, both witnesses complete their testimony in time to take their pre-planned travel, but we in fact fit in another witness essentially after that. And we would have completed that witness if not for a government objection at the end of the day that prompted a sidebar. So the defense is certainly cognizant, and has worked with the government to move that part along. And we simply don't understand when Mr. Finkel says something like, it will allow the jury to catch up on their lives, when what he's actually talking about is taking away 2 hours from them and having jurors who could be in Westchester having to leave the courthouse at 4:30 or 5.
Mr. Finkel said, "I think the question for the jury, Your Honor, is whether the jury wants the trial to end, as the court predicted it would on July 12th, or whether they want to sit through the end of the month. And I don't know what's in their minds, obviously, but that's really the question. And so I don't think there's a prejudice to sitting an additional hour and a half each day at trial. We're all here. We're all on trial. I am sure the defense team is working as hard as the government team, which is basically 24/7. 7 days a week, which is what we've been doing for months now. I'm sure they have been too. That's the nature of trial practice, in this district, especially. The government's view is that in order to meet the July 12th date, which the court told the jury about, we need more time. There are a variety of reasons. We can point fingers at each other as to who is responsible. But we are where we are. And so we ask the court to consider and ask the jury to sit full days next week. And we can turn to the other issues, if Your Honor would like."
The court said, "Yes, if you would please."
Ms. Murray said, "Your Honor, with respect to Mr. Khaled's cross-examination, just before we started today, Ms. Shroff advised me that she would like to question Mr. Khaled about a recording that the government produced in discovery. It's not one of the recordings that we introduced in our direct. I've asked Ms. Shroff the basis for her trying to admit it. We don't dispute the authenticity, but we do dispute its admissibility and relevance. It's a Zoom or WebEx recording of an interview that Mr. Khaled and 2 others did of a potential candidate a few years ago. Our understanding is, it's the way that WebEx or Zoom automatically records sessions. And it happened to be saved onto his computer. In looking through all of his possessions and giving the government recordings, he produced that. So we don't see any reason for it to be introduced. We don't see its relevance. To the extent Ms. Shroff wants to establish that he recorded other conversations, she can do so through questions. But it's hearsay, and there's no basis for it to be admitted into the case."
The court said, "What is discussed during the recording?"
Ms. Murray said, "It's an interview of a candidate for a position at G Clubs. So the interview is conducted by Limari Reyes, the CEO, by Alex Hadjikaralambis, the financial controller, and by Mr. Khaled. One is the interview of the candidate and the second is the feedback session. Internal feedback session.
The court said, so I assume that it concerns the qualifications for the individual. Is that the subject matter?
Ms. Shrofa said, thank you, Your Honor. The subject matter is not that limited, Your Honor. First, the only person who seems to have had this recording is Mr. Khaled. I would like to be able to tell the jury that Mr. Khaled recorded not just quote-unquote random calls, but he recorded a lot of things just because maybe he's a serial recorder. I don't know, but that's not important why he recorded. The second thing is, the conversation and the interview itself is relevant. Mr. Khaled lies during the interview. He tells the the applicant that he has been at GTV for 4 years, at GTV for 4 years, which is false. He also talks about the setting at GTV at that time. And the other participants who are interviewing the candidate are very candidly telling the candidate that the office is chaotic. And they're looking for a person with experience who can actually deal with chaos. So even if those statements aren't true, the point is that they were made. It reflects Mr. Khaled's state of mind. It shows his awareness that this was a growing company, that everybody was taking steps to make sure that the holes in the personnel group were being addressed. Mr. Khaled said that that was not the case, that all of this was just nonsensical and, he was so disillusioned. So that makes this conversation relevant. I do not intend, and I just want to be very clear in this cross, unless the witness testifies a particular way. I have no desire to replay the calls that were played yesterday or to play the entirety of this call. I asked the government to stipulate to its authenticity so that we could save time. And I obviously don't need to have him listen to the entire call, Your Honor.
The court said, so with respect to what you say is a lie on the call, you're wanting to use the call to impeach Mr. Khaled.
Ms. Shrofa said, not just to impeach him, also to show that he had a particular state of mind. That's how he perceived himself. He sells himself as part of this group, as having a long relationship with them. He describes the relationship with them, which is quite contrary to the relationship he says on direct to the jury that he had reformulated by that time.
The court said that he had reformulated?
Ms. Shrofa said, right. So he says, I started out at GTV with such enthusiasm, and then I became disillusioned, and I thought it was a big scam and it was all a fraud. And he's participating in a job interview where he says, come on board, join us, we're the greatest. So I think that that's part of the reason why the call itself is relevant, Your Honor.
The court said, and what about the issue of the chaos that you're describing? How is that pertinent?
Ms. Shrofa said, because Mr. Khaled said that, his first week there was so chaotic. Nobody knew what they were doing, people ignored the problems. Here is an example of not only was the problem not ignored, they had identified the problem. The place was new. It was a startup, there was a lot of chaos, and they're looking for an applicant. They're looking for a potential employee who can help them with chaos. I believe that there is an actual interview question put to the applicant that says, give us an example of how you would deal with a chaotic work environment. That's what we are. So there was no lying. There was no hiding anything. This was a real entity, trying to build a real business, and we should be allowed to show that.
The court said, and how long is it?
Ms. Shrofa said, I don't know how long it is. But I really do not mean to. I don't need to play it even more than like a clip. Even if I don't play the clip at all, I would still seek it to be admitted, because part of the reason we admit everything, Your Honor, is not just to show to the jury, we also admit it because we want to use it at summation. And that is also, candidly, why we'd like the recording admitted. Not only the government knows of the existence of this recording, I'm sorry that they found out late. We'd known about it before, and it was always part of our cross.
Ms. Murray said, Your Honor, the defense is trying to admit this as extrinsic evidence to impeach the witness. It's improper. First of all, if they were to do that, they would first need to confront him as to whether he lied. And that hasn't been established. I don't think that there would be any basis for that. From what I'm hearing from Ms. Shroff about why she's seeking to admit it, the statements on the interview are entirely consistent with his testimony. There were people who were working at G Club. Ms. Reyes is a participant in the interview. She became the CEO in April, interim CEO in April of 2021. So this isn't the first week. When he said it was chaotic and there was no infrastructure. This is further along in his time when he was working at GTV and G clubs. Yes, it was consistent with what he said. They were starting to build a team, but later, his understanding was that it was all just a money laundering operation. Effectively. It also doesn't go to his state of mind. And the government's view is there's no basis, to introduce this audio. The last point I would make is it's unquestionably hearsay. There is no question that it's hearsay. And the government doesn't think that it should come in at all.
Ms. Shrofa said, Your Honor, they've, throughout this case, maintained that the companies are just a sham. Whether it's at point 1, point 6, or at the end. All throughout. Their whole testimony is they went through all of this. Ms. Murray spent 5 questions asking just about how she stopped the tape to say, and what do they call these people? They call these people investors, not members. What did they do? They did nothing. Did they get any benefit? No. They didn't. Time after time, pause after pause, when that document is in evidence, the tape is in evidence. And all she had to do is skip over all of that and just sum up on it. Like Judge Kaplan says, the document speaks for itself. So for those reasons, we are allowed to show that this was not in fact a scam. This was not just a shop front. This was not a money laundering operation. People were working throughout that time to make it a real entity. And Your Honor, they're the ones who charged the RICO. They keep calling it a fraud case. It's not a fraud case. We're allowed to show, in fact. Failure of the defense to raise the issue that it is an actual real business is a 2,255 in the making. I'm entitled to show it was a real business.
Ms. Murray said, Your Honor, Ms. Shroff can question the witness about all of these topics. The question here is the recording, and whether the recording is relevant and admissible, and it's not. It's an out-of-court statement that she's proposing to offer for the truth. I would also note. The government's position in its case has not been that these companies didn't exist. It's not that they weren't real. It's that they were put into place effectively as instrumentalities of a RICO enterprise. There were real employees. Ms. Reyes, we expect to testify, she was the CEO, she believed she was operating a legitimate membership company. But at bottom, the people who were actually in charge, Mr. Gov't and his key co-conspirators. They were the ones who knew that they had created this shell game in furtherance of this massive multi-billion-dollar fraud. And another point I'd make, Ms. Shroff said she wants to introduce it to show that the witness, I think she said, recorded all kinds of conversations. Aside from the recordings that the government has discussed with the witness and the additional recordings from that time period, which were support to the stipulation, this is the only other recording we're aware of. As I said, it's our understanding that this is automatically recorded during a Zoom or WebEx session. You can press a button and you can record a meeting, and that's how this came to be. It just happened to be saved onto his computer. So he provided it to the government. And lastly, again, Your Honor, it's just classic hearsay.
Ms. Shrofa said, The only person who pressed the button, Mr. Khaled. The other people did not press that button. More importantly, if the government is going to stipulate that in fact these were real businesses, and they are, they'll agree that that element of the offense is not met by the government. We're happy to just skip all of the testimony as to whether or not this was a proper business and a functioning business. And I remind the court, Your Honor, over and over again Ms. Murray asked him, did G clubs provide any benefits? Did G clubs provide any services? She paused the tape and said, Is there any discussion here about services by G clubs? No.
The court said, I'm going to permit the tape.
Ms. Shrofa said, Thank you.
The court said, Is there anything else?
Ms. Shrofa said, No, Your Honor. Your Honor, is the government. May I just have a minute?
Counsel conferring.
Ms. Murray said, Your Honor, one more issue. with respect to the matters that were raised yesterday with Mr. Khaled and the court advising him to speak with his counsel. It's our understanding from his counsel that they had the opportunity to speak. It's also our understanding that he intends to respond to any questions that are posed to him. But we would ask that the defense not be permitted to inquire in any way into the court's conversations with the witness yesterday, including advising him of potential exposure he might have in answering those questions. That would be 403. And we firmly believe that the defense cannot inquire into that.
The court said, "So I'm sure they don't intend to inquire about my discussion. Isn't that correct?"
Ms. Shrofa said, "Of course not, Your Honor."
Mr. Ferguson said, "And, Your Honor, I have apologies. I think last on the menu, I have one other issue. It relates to a victim witness the government expects to testify today. And I just want to at least give some context for the court. It may be that we can take it up at the lunch break. But this is a victim witness who was a member of the Mountains of Spices farm. She did translation volunteer work for that farm. She was in a chat group, it's either WhatsApp or Discord chat, with other members, and with, other volunteers who did translation work. 3 or 4 exhibits that the government intends to offer through this witness are documents that were shared in that group. They were shared by Zhang Yongbing, who, if Your Honor recalls, was the attorney who tried to coerce Ms. Yali into signing a false affidavit. He was a lawyer. And he shared these documents with the group. She didn't really work on them, but she has copies of them. Just to give Your Honor a sense of what they are. They're not legal. I understand the defense has said that Mountains of Spices, the New York farm, intends to claim privilege on these 3 exhibits. Just to give Your Honor a sense of what these exhibits are. One is a screenshot of a conversation between Mr. Gov't, William J., and Sarah Way about reconciling the farm loan program wire transfers. It's a screenshot of a WhatsApp conversation between them. And it just lists out, sender, date, and dollar amount. That's one. The other 2, I believe, are 2 or 3 are Excel sheets that show, again, similar information, just wire transfer information. There's no legal advice at all in any of these documents. And the government does not think there's any valid claim of privilege on any of these documents. Just wanted to raise that so that we possibly can avoid any sidebar during the victim's testimony. We're hoping to, consistent with Mr. Finkel's statements earlier, streamline this victim's testimony, to keep things moving at a good pace."
Mr. Skirek said, "Your Honor, I think Mr. Ferguson is leaving a few key facts out of his description that are relevant here to the claim of privilege. And I will just say that it's my understanding that outside counsel for Mountains of Spices, who either may be here or will be here shortly."
The interpreter said, "Counsel, you need to speak into the mic."
Ms. Shrofa said, "Sure. I'm sorry. Apologies. That counsel for Mountains of Spices, who is either here or will be here shortly, will assert privilege formally. So that's number 1. Number 2 is that what the defense just learned last night for the first time, because
The court said, "Wouldn't it be Mr. Gua's privilege to assert?"
Ms. Shrofa said, "No, Your Honor. So the communications are communications that take place on a chat. On a Discord chat, and perhaps another chat, platform chat, that relate to a lawsuit that Mountains of Spices, which is the New York farm, brought against Sarah Way, who Your Honor may recall was at one point in charge of VG, who took in money from the private placement. And Mountains of Spices' claim was that she stole the funds. And they sued her. And so the communications that are at issue here, including the spreadsheets and including the screenshot that Mr. Ferguson referred to, are communications that are taking place in the context of that lawsuit. And, even more specifically, Your Honor, this alleged victim has a confidentiality agreement that the government first produced to us last night. That specifically says that she is at the top, and we can certainly show it to the court to give the court more color. But it says at the top that the translation services that this person is providing are in connection with that lawsuit. And then it goes on to, essentially it's a standard NDA that says you'll keep everything confidential, Because she's providing those services in connection with the lawsuit by Mountains of Spices. So those are just some additional facts that to help give the court color. Now,
The court said, when is it that you expect this issue to arise?
Mr. Skirek said, I think we anticipate, and Mr. Ferguson can speak to this better than I, Your Honor, it's his witness. But I think we anticipate that it will be today, assuming that we get to this witness. I think she's following Mr. Khaled. She's number 2 up after Mr. Khaled, if I understand correctly.
Mr. Ferguson said, that's right. It's Khaled, Ms. Espinoza, and then this victim.
Mr. Skirek said, so, Your Honor, our view is that, look, Mountains of Spices has asserted privilege. There's certainly a valid privilege claim here that would need to be dealt with respect to these 4 or so documents. I think we're in agreement as to what documents this applies to. There are 4 of them. And that issue needs to be resolved certainly before the government intends to ask the witness about them.
The court said, your position is that these 4 documents pertain to the lawsuit.
Mr. Skirek said, correct.
The court said, go ahead.
Mr. Ferguson said, that doesn't mean they're privileged, Your Honor. They're not legal documents. They're spreadsheets. And there's a screenshot of a WhatsApp chat, not with any lawyers. They're not privileged, one, just there. And the second is, Your Honor, this is a victim of Mountains of Spices. Like they had these victims. As Your Honor has heard over and over, sign various agreements. And that was part of the scheme to defraud. This is not a valid claim of privilege in any sense. It's not privilege. To the extent there were any to the extent the court has any concern about maybe there is some privilege here. It's clearly crime fraud, Your Honor. There is no way that the farm loan program is not subject to the crime fraud exception. And you don't even need to get there because these are just not privileged. They're just screenshots of Excel sheets.
The court said, what would make those screenshots and Excel sheets privileged?
Mr. Skirek said, so one of the principal issues as I understand it in the lawsuit. And certainly outside counsel for Mountains of Spices knows better than I and may be able to correct me. But my understanding, Your Honor, is one of the principal issues was, how much money had been stolen. You know. Essentially what the damages were, what Mountains of Spices damages were and what it proved. And these spreadsheets appear to have been circulated by lawyers in the Discord chat too, as part of having. You know, and there are a number of portions of the documents that are in Mandarin. And so they're circulated to this group as part of the effort on Mountains of Spices' side to decide what quantum of damages to assert and what they can prove.
The court said, so this is Mountains of Spices saying what about the defendant?
Mr. Skirek said, they're not saying anything about the defendant, Your Honor.
The court said, in the action they are asserting claims against the defendant. What are the claims?
Mr. Skirek said, sorry. Yes, Ms. Wei, yes.
The court said, they're claiming that Ms. Wei misappropriated the funds, correct?
Mr. Skirek said, correct.
The court said, all right. This is all part of the RICO enterprise and they come in. Anything else?
Mr. Ferguson said, no, Your Honor. Thank you.
Mr. Skirek said, we have one other issue, I'm sorry. Your Honor, that also relates to a witness that may come up later today and maybe even, are we confident of that? Okay. Well, just a preview for Your Honor. There is the witness who will follow the victim that we were just speaking about, Mr. Roberts. Who is a representative of a company called BitGo, which was an outside vendor of the Himalaya exchange. And Mr. Roberts, and the defense sent a letter on Monday. After we received Mr. Roberts, or noticed that Mr. Roberts would testify this week. Letting the prosecution team know that we believe that what appears to be his anticipated testimony is actually expert testimony that was not noticed. It appears that the government plans to have Mr. Roberts testify about issues like whether or not the cryptocurrencies at issue were real cryptocurrencies. Which Your Honor will remember was the subject of extensive briefing with respect to the dueling experts that the parties have here. And so we gave the government notice seeking, well, not so much notice. We wrote them a letter seeking assurances that they wouldn't elicit that kind of testimony. Which is the proper subject of expert testimony. And we just heard back for the first time this morning in the discussion before Your Honor came out that the government takes the position that Mr. Roberts can speak to those issues. And I don't mean to mischaracterize, Mr. Horton can correct me if I got that wrong, but my understanding is that the government's position is that he can testify to those issues because essentially it was part of his job when he was at BitGo to review and do due diligence, and so to the extent that he came to conclusions about the coins or about the exchange, that he can testify to that. And again, our view, I think, and it's pretty clear, is that that's actually expert testimony.
The court said, "Are we expecting Mr. Roberts?"
Mr. Horton said, "No, Your Honor, we're not expecting him today. And in the interest of time, we have a short letter prepared as to his testimony and why it's admissible."
The court said, "All right, so we'll revisit that at a later time, if you'll have the jurors brought in."
Jury present.
The court said, "Please be seated. Good morning, jurors."
The juror said, "Good morning."
The court said, "So I have some good news, and that is that next Wednesday we will not be meeting. You'll have next Wednesday off. But due to circumstances beyond my control and beyond the control of the parties, we are running late. And what I do not want to do is to have to extend the trial beyond the July 12th date that I gave you as the end date for the trial. And so for next week only, I'm going to make a proposal. You don't have to answer me now. You can think about it over the lunch break. But in order to catch up and not have to extend the trial, I am proposing that for 4 days next week, Monday, Tuesday, Thursday, Friday, that we go from 9:30 to 1 p.m., that we have a 1-hour break for lunch, and that we then go from 2 to 5. So think about that. Think about that. And you'll come back, and we will continue our discussion after the lunch break. Mr. Khaled, remember that you're still under oath. We'll continue with the cross-examination.
Ms. Shrofa said, "Thank you, Your Honor."
Haitham Khaled. Resumed. Cross-examination. By Ms. Shrofa.
Good morning.
Good morning.
Mr. Khaled, let me show you what is marked as Defense Exhibit 60538. Ms. Shrofa said, "It's just for the witness." Thank you. Sir, if I could ask you, if you could take a look at the document. Do you recognize this, sir?
Yes.
And what is it?
It's a affidavit.
Whose affidavit?
Pacific Alliance Asia Opportunity Fund.
Let me try it again. Who signed the affidavit?
Who signs the affidavit?
Yes.
I signed it.
Ms. Shrofa said, "Your Honor, at this time the defense moves Defense Exhibit 60538 into evidence."
The court said, "No objection?"
Ms. Murray said, "Your Honor, objection for the moment. We don't understand the purpose of this exhibit."
The court said, "All right. So if you'll step up, please."
Continued on next page. At the sidebar.
Ms. Shrofa said, "Your Honor, Mr. Khaled makes a statement under oath in paragraph 5 of the affidavit. I don't think he's going to find it there. But essentially saying that he has no relationship, Crane has no relationship with Mr. Kwok, and he says that under oath."
The court said, "So you're going to confront him, you're going to ask him. Did you say on X date X thing?"
Ms. Shrofa said, "No. I'm just going to ask if the affidavit is signed under oath, if he signed it, and if paragraph 5 accurately reflects the fact he put down in the affidavit."
The court said, "But the purpose is impeachment."
Ms. Shrofa said, "It's also to show his state of mind on May 17th, when he signed the document."
The court said, "This is for impeachment, and so you can confront him, and you'll have to live with his answer if he says yes."
Ms. Shrofa said, "Okay."
The court said, "All righty."
Continued on next page. In open court. By Ms. Shrofa.
Mr. Khaled, you signed an affidavit, correct, in the Pax litigation?
Can you repeat that?
Sure. You signed an affidavit, did you not, and submitted it as part of the Pax litigation?
Yes, I did.
Ms. Murray said, "Your Honor, I ask that the document be taken down unless and until it's admitted."
The court said, "It's not being shown to the jurors."
Ms. Shrofa said, "No."
The witness said, "But can I see the entire one? There's a page 1 to 3.
The court said, "You may look at that. Go ahead."
Ms. Shrofa said, "May I approach, Your Honor?"
The court said, "You may."
Ms. Shrofa said, it might be easier for the witness to have a hard copy.
The court said, "Oh, I see what you're saying. That's all right."
Can you repeat your question?
My question was, do you remember signing an affidavit and submitting it as part of the Pax litigation?
This affidavit, yes.
And when you submitted that affidavit, you knew that you were submitting facts that you were swearing to as truthful, correct?
On actual facts.
Yes.
And documents that I had, yes.
Okay. And you recall that the affidavit was notarized by a notary, correct?
Yes.
And as part of the affidavit, you made certain statements, correct?
Yes.
And one of the statements that you swore to under oath was that you had no information demonstrating that the Citibank account nor any Crane Bank account has or has had any funds belonging to Kwok or any entities that he has a financial interest in, correct?
On paper, yes.
You swore to that under oath, correct?
That on paper, yes.
Okay. Could you explain to me what you mean by on paper?
So none of the payments that came in that were on Crane did not have Kwok as a name. As a beneficiary. Kwok's name was not on it.
Well, but you said that they had no funds belonging to Kwok, right? Funds can belong to someone without their name being on it, correct?
The court said, "Don't testify."
What did you mean when you said any funds belonging to Kwok?
That his name was on there.
So your affidavit, when you say something belongs to you, you mean that your name has to be on there.
When it comes to funds and the documents that I had, the statements, correct.
And then you said, or any entities that he has a financial interest in, correct?
Yes.
And by saying that, did you also mean to say on paper if his name appears? Or did you actually mean to say what you wrote and swore to under oath? Any entities that he has a financial interest in?
My statement was based on the paper.
The court said, "What do you mean based on paper?"
The witness said, based on the actual wires that were in the account.
The court said, "Could you explain that more fully?"
The witness said, okay, so there's 1,300 wires, transfers that came into the account, which was at Citibank's account. So all these payments did not have specifically the name of Kwok on them.
The court said, "Go ahead."
By Ms. Shrofa.
Okay. And you said, I have no information demonstrating that Citibank account nor any Crane Bank account has or had any funds belonging to Kwok or any entities that he had a financial interest in, correct?
That's what it says, yeah.
And you testified on direct, did you not, Mr. Khaled, that the wires that you received for G Clubs, Mr. Gov't had control over, correct?
Correct.
And if he had control over them, did you believe that he had a financial interest in those wires?
Yes.
So when you said that he has no financial interest in it, that was not a truthful statement, correct? According to you?
In theory, no.
How about in practice?
According to the documents of the account and the wires.
Did the affidavit say, according to the documents and the wires?
Ms. Murray said, "Objection, Your Honor."
No funds belong.
The court said, "Overruled."
To Mr. Kwok. But I personally believe that he has a financial interest in all the money coming into G Clubs. Did you say that in the affidavit?
No.
And could you tell the members of the jury the date of the affidavit?
May 17th, 2021.
And by May 17th, 2021, how many recordings had you made?
I don't remember the exact number.
Okay, let me move on. Mr. Khaled, between November 23rd of 2020 and May 13th of 2021, did you move about $108 million?
Can you repeat the dates?
November 23rd of 2020 and May 13th of 2021.
I might have, yeah.
Let me show you what is marked as Government Exhibits MSS 80 and MSS 96. Now, while we're pulling those documents up, Mr. Khaled, do you have any significance attached to the May 12th, 2021 date?
Do I have a what?
Do you have any significance attached to May 12th, 2021?
I'm not sure.
Okay. Now let me direct you to the bottom right of the front first page, okay? You see the account number? And I apologize for the quality of the document. You see the account number, which is 5520699134.
I see the number, yeah.
Okay. And if you look at page 7 of the same exhibit ending in 80, do you see the January 26, 2021 transfer of $5,000 to an account ending in 136, which will be Government Exhibit 96? Do you see that?
Yeah, but can you show me the actual statement, or no? I can't see the statement.
Does that help you?
Millimeter whom?
Do you see on the top column on the right?
Yes.
So if I could highlight that for you just to make your life easier.
Thanks.
Active asset account, correct? I can't tell if it's asset or assets. I apologize. I don't mean to purposely mislead. On the very top, if you could highlight it for him, Crane Advisory Group, LLC. Care of Haitham Khaled, correct?
Yes.
And that is the 136 account, correct?
Correct.
And that's your personal Morgan Stanley account, correct?
The one highlighted?
No. The one into which this money is going is your personal Morgan Stanley account, right? Which is Exhibit 96, the document ending in 96. Do you see that transfer?
Yeah.
Okay. And you transferred $5,000 into that account, correct?
Yes.
Okay. And that is dated January 26th, 2021, right?
Correct.
Okay. Now if we go to page 7 of document ending 96, would you tell the jury where that money came from?
The 5,000?
Yes.
From the other Morgan Stanley account.
And what is the name on the other Morgan Stanley account?
Crane.
And then there is another transfer, if you look at page 30, of $1 million, correct? We're now back at 80. Government Exhibit GXMSS 80. You see, on page 30, there's a $1 million transfer, correct?
Correct.
And then another $1 million transfer, correct?
Correct.
That's exiting the Crane account, correct?
Yes.
And that money is going where, sir?
Account ending 136.
And who is the owner of 136?
I am.
It's your personal account, correct?
Correct.
The first transfer is on April 5th of 2021, correct? And the second transfer is on April 20th?
Yes.
Thank you. Now let's go back. Ms. Shrofa said, you can take that down, please. Thank you. Is it fair to say you also transferred money from the Crane account to your personal account at Capital One?
I need to see it.
You don't remember it?
No. There was a lot of transfers.
Do you recall a transfer for $129,000?
I need to see it again.
Let me see if I can show you a document that might refresh your recollection, okay?
Sure.
Ms. Shrofa said, this is just for the witness and not the jury, please. Do you see the third bullet point?
Yes.
Does that refresh your recollection of that transfer?
No.
Okay. Did you have a Capital One account?
I did.
Ms. Shrofa said, and could we go to the very top of the document that is in front of Mr. Khaled? Does that refresh your recollection about the transfer?
No.
Ms. Shrofa said, okay. You can take that down. Mr. Khaled, you testified on direct about your fee, correct? You remember that?
Correct.
And you testified on direct that you felt you were entitled to a $2.7 million fee, correct?
Correct.
Now to earn a $2 million plus dollar fee, you would have to clear more than $100 million, correct?
Correct.
And you had not cleared anywhere close to that amount when you transferred $2 million to your personal account from the Crane account in April of 2021, correct?
Correct.
You were not entitled to that amount even under a simple mathematical calculation, correct?
What do you mean entitled?
You testified yesterday that you thought you were entitled to this fee. 2% of all the money you cleared, correct?
Correct.
Okay. So mathematically, when you took the $2 million, even just by math, you were not entitled to it. Correct? Because you could only get 2% of what you had cleared, and you hadn't cleared that much, right?
Ms. Murray said, objection, Your Honor. Compound.
The court said, sustained.
Ms. Shrofa said, I'm just trying to save time. I'm happy to go through it step by step. Really, I am.
The court said, all righty. Just break the question up.
Can you?
You want me to try again, Mr. Khaled?
No. Can you?
I'm sorry?
Can you?
Sure.
Repeat?
Sure. You said yesterday that you were going to charge a 2% fee, right?
It was agreed with Yvette and my son, Anna, so it's not me charging them directly. Go ahead.
Whoever agreed to it, you were charging the fee, right? Yvette's not charging the fee, right?
Correct.
Ms. Murray said, objection, Your Honor.
My son is not charging the fee, correct?
The court said, he has answered yes.
Okay, so I'll move on. To charge a 2, for you to get $2.7 million as 2% of an amount. You would have had to clear more than $100 million. It's just simple math, correct?
Correct.
Okay. And by April 2021, you had not cleared more than $100 million, correct?
Correct.
So you just arbitrarily transferred $2.7 million from the Crane account into your personal account, right?
No. I believe the 1 million was transferred back. I think there was a mistake.
I didn't ask if it was transferred back, sir. I just asked you, based on the documents I showed you. The $2 million were transferred into your personal account.
Yeah.
Okay.
Again, my answer is that 2 million, a million of it was, or maybe both, transferred back. I don't remember the exact transactions back and forth.
I'm sure Ms. Murray will clean that up on redirect.
Ms. Murray said, objection, Your Honor, objection.
The court said, sustained. Don't testify.
Sitting here today, your testimony is that the $2 million of the 2.7 was transferred back? I just want to make sure I get it right, or we can have the answer read back.
I don't remember every transaction.
Okay, so when you agreed with these 4 prosecutors, 3 prosecutors over here to forfeit $2.7 million, you're really forfeiting money that you never even got, or that you got and transferred back.
Ms. Murray said, objection, Your Honor.
The court said, sustained. Too many concepts in the question. You need to break it down.
You agreed to forfeit $2.7 million, correct?
Correct.
Now you're saying that the $2 million that was transferred into your account was transferred back to G Clubs, correct?
Ms. Murray said, objection. Mischaracterizes.
The court said, sustained. He said that he could not recall exact numbers.
Okay, tell me your approximate number that you think you transferred back.
I can't really answer. I don't remember.
Was it 1 million?
Ms. Murray said, objection, Your Honor.
The court said, sustained.
So you transferred some amount back. That's your testimony, right?
Correct.
To G Clubs.
No, back to the Crane account.
You transferred it back to your Crane account?
Correct.
So you kept it in your Crane account.
Went back to the Crane account, and then when the clearing happened, when we did the clearing, it either went to G Club or it stayed or became part of the fee.
So then why, if it went back to G Club, did you agree to forfeit $2.7 million?
Again, it went back to Crane, and then it was cleared for G Club.
Okay.
And then a fee was earned.
Right. But why did you agree to give it back to the government if it was lawfully earned?
Ms. Murray said, objection, Your Honor. Asked and answered.
The court said, you can answer. Why did you agree to give it back to the government to return the money? Clarification. Why did you agree to forfeit the money? Ask.
Ms. Murray said, Your Honor, would just note, we would.
Ms. Shrofa said, Your Honor, she can't testify either.
Ms. Murray said, Your Honor. I'm simply asking that the court note that Mr. Khaled is not obligated to get into any discussions with his counsel about that topic.
The court said yes. It's not a question of revealing a discussion with his counsel. He's just being asked, why did you agree to forfeit $2.7 million?
The witness said, it was part of the agreement. By Ms. Shrofa.
You met with the government, Ms. Murray, Mr. Finkel, Mr. Ferguson, on July 26th of 2021 with the FBI, correct? Remember that?
July?
How about on March 31st of 2022?
Probably.
Did you tell them, I sent this money back into the Crane account?
I don't understand your question.
You just said you transferred the money back to the Crane account and some of the money to G Clubs. You just testified to that, right, now?
The court said, that was not his testimony. He did not testify that the money transferred from his account went to G Clubs.
Ms. Shrofa said, Your Honor,
The court said, he testified that it went from his account to the Crane account.
Ms. Shrofa said, he said some went to the Crane account, some went back to G Clubs.
The court said, that was not his testimony.
By Ms. Shrofa.
Could you clarify where that $2.7 million went back, according to you?
The 2 million?
Yes.
Not the 2.7.
The $2.7 million.
The court said, all right. So I understood you to be asking about the $2 million. So now you're asking about the $2.7 million?
Ms. Shrofa said, I'll break it up, Your Honor. The $2 million, you said you transferred it back, correct?
I transferred. It was transferred back to the Crane account.
All $2 million.
Ms. Murray said, Your Honor, objection. It mischaracterizes. He said he doesn't recall the specific transaction.
Ms. Shrofa said, it's a question.
The court said, where did you transfer the $2 million, from your account to where?
The witness said, it either stayed in that account. I don't remember if the entire amount stayed in that personal account or transferred back. Most of it transferred back to Crane, as an error. By Ms. Shrofa.
Did you tell Ms. Murray that when you met with her on March 31st?
I don't think I was asked.
Did you tell her that when you met with her on May 12th of 2022?
No.
How about on June 27th of 2022? Did you tell her that?
Again, I don't remember.
July 7th, 2022, you met with her again. Did you tell her then?
Again, I don't remember.
November 2nd, 2022, you met with her then. Did you tell her then?
Again, I don't remember.
January 10th, 2023, did you tell her then?
I don't remember, no.
March 7th, 2024, did you tell her then?
No.
March 8th, 2024, did you tell her then?
I don't remember.
March 14th, 2024, did you tell her then?
Ms. Murray said, objection, Your Honor. 403.
The court said, you may answer.
Again, I don't remember.
March 25th, 2024, when you met with her, did you tell her then?
Tell her that I made an error wiring money back and forth?
Anything to say or show that this money went back to where you said it went back to. Let me try it this way. There is a digital record of money going back and forth from accounts, correct?
Correct.
Did you ever tell her there's a digital record? Here it is?
I believe statements were presented.
Continued on next page. By Ms. Shrofa.
I asked you if you presented any statements to her showing any transfer from your personal account into the Crane account after April of 2021.
My entire discovery was sent through the lawyers, so I don't see.
Okay. Is it fair to say up until all through these dates you and Ms. Murray never discussed that topic? Correct?
The topic of transfers?
Yes. Transfers back from your personal account to the Crane account that you've testified to now under oath?
The court said, what dates are you asking about?
Ms. Shrofa said, all the dates that I just recited, Your Honor. I didn't want to repeat them.
The dates of the transfers, like exact transfers one by one.
Yes, exact transfers one by one.
One by one, I really don't remember one by one.
How about as a group?
What do you mean as a group?
I ask you if you remember them as a group?
I don't remember specific transfers, no.
How about on March 31st of 2024? Did you discuss this issue with her then?
I don't remember, no.
You met with her on May 7th, correct, of 2024?
I don't remember the exact dates.
May 20th, 2024?
Again, I don't remember exact dates.
May 27th, 2024? You met with Ms. Murray May 27th, 2024, correct?
I don't remember exact dates.
May 29th, 2024?
Could have. I don't know.
June 1st, 2024?
Might have been.
June 6th you sent her emails, correct?
I might have, yeah.
June 6th you met with her again, correct? Do you recall telling her I transferred these monies back out of my personal account?
Again, I want to clarify. The money came to my account. It transferred to.
Can you just use your mic for me because I have trouble?
The money came into the account and then transferred back to Crane.
Well, it didn't come into your account, right? You had to transfer it?
It transferred from Crane to the personal account and then returned to Crane.
Did you ever tell her that? In the 19 times you met with her, did you ever tell her that?
No.
And the money didn't just move from the Crane account into your personal account, right? Only you can release funds from the Crane account, correct?
Ms. Murray said, "Objection, Your Honor, compound."
The court said. He testified that he made the transfer, that it wasn't a spontaneous transfer.
Could you tell me, sir, what is a non-spontaneous transfer?
The court said. I'm characterizing.
Ms. Shrofa said, "Oh, I apologize."
The court said. He said that he made the transfer.
June 8th, 2024, you met with Ms. Murray, correct?
Could have, yeah.
Never told her about this transfer, correct?
Ms. Murray said, asked and answered.
Ms. Shrofa said, I did not ask about June 8th.
The court said, why don't you just go through all the dates? Name the dates and ask him whether he stated that he made the transfer on any of those dates.
June 6th, June 8th, June 9th, June 10th, and today is June 12th. That's just last week?
No.
What money did you use to buy your 7 properties if you sent this money back to Crane?
From the 2%.
Excuse me.
I bought those properties from the 2% fee.
The 2% fee which is included in the $2 million we just talked about?
No, that's what I was trying to clarify.
Okay, go ahead.
So money went back. And then when it was cleared, I took the fee from the cleared amount.
Oh, so you sent it back. Then you waited to clear the 2% amount. And then you used that money to buy properties. That's your testimony?
Yes.
You've reviewed your bank records, correct, to prepare for your testimony here?
Yes.
There's no such document that you reviewed, correct, that shows these transfers?
What do you mean?
There's no bank account that shows any transfer from your personal account into the Crane account, correct? It only shows transfers from your Crane account into your personal account?
Ms. Murray said, objection to testifying.
Ms. Shrofa said, it's a question.
The court said. You may answer whether or not there are documents showing a transfer from your account to the Crane account.
The ones that she showed me here?
The court said no whether there exist any documents that show that.
Could be, yeah. A statement, yeah.
It could be?
No, there's a statement.
There is a statement that you... Did you show that statement to Ms. Murray?
Again, everything was produced.
You reviewed a lot of documents with Ms. Murray to prepare for your testimony here, correct?
Yes.
You never reviewed any documents with me, right?
No.
Is it your testimony under oath that you reviewed such a document with Ms. Murray?
Ms. Murray said, asked and answered.
The court said, sustained.
You worked out a payment facilitation agreement, correct?
Can you be more specific?
No. Did you work out a payment facilitation agreement with G Club?
Yes.
Have you worked out payment facilitation agreements with anyone else?
No.
You listened to several recordings yesterday, correct?
Correct.
Each one of those recordings was made by you, correct?
Correct.
And on those recordings, and I'm hoping I don't, I take that back. You testified that you heard and listened to different people giving you different options for the way money could be moved out of the Crane account. Correct?
Correct.
You testified you were on the recordings discussing the need to do a Know Your Customer, correct?
Correct.
And that's one of the reasons you gave on the recordings as to why you could not move the money out of the Crane account because according to you, you had not yet finished Know Your Customer, correct?
Correct.
And you've been a banker for how long? 10 years, a decade. Is that right?
Approximately.
And you know, sir, that it is the bank that receives money that does KYC, correct?
They do KYC, correct?
Right. In fact, if they hadn't done a KYC, there would be no money in your Crane account, correct? It would have been one big zero?
Correct.
And, in fact, the only reason you were able to transfer money out of your Crane account into your personal account was because KYC had been done, correct?
No, that's not accurate.
Really? How did you open your Crane personal account? Was KYC done when you opened the personal account?
At Morgan Stanley?
Morgan Stanley, Citibank, anywhere. Each time you open an account, the bank does a KYC, correct?
Correct.
Banks.
But the money that was in Morgan Stanley came into Citibank and Capital One to Crane's account. And then when it went to Morgan Stanley, it went from Crane's account, so not the 1,300 people.
You finished?
Yeah.
The money that came into the Crane account, the banking institution did the KYC, correct?
Yes.
Not you?
No.
Not Crane?
For the money that came in, Crane did not do it.
By that you mean KYC, correct?
Correct.
Let me go back to the recordings. On the recordings, people suggested to you the different ways you could get the money out of the Crane account, correct?
Correct.
One option presented to you was to simply send the money back to the original sender, correct?
Correct.
You did not do that?
I did for a few wires.
How many?
Don't remember. There was a number of returns.
I'll come back to a specific recording later, but your testimony is you don't remember how much, correct?
Returned?
Right.
I don't remember exactly, no.
A second option presented to you, correct, was for you to simply close down the Crane account, right?
I don't remember that.
You don't remember Ms. Wang telling you that you should just simply close the Crane account? If you closed the Crane account, she informed you, you would just stop receiving funds, correct?
I don't remember that, no.
In fact, she told you that in a call that you recorded on April 30th, correct?
Again, I don't remember that.
All right. Ms. Shrofa said, "May I have a moment, Your Honor?"
The court said, "Go ahead."
Does that refresh your recollection, sir, that on April 30th of 2021, Ms. Wang told you Crane should just close down the account instead of receiving further funds, correct?
I don't know this word she's talking, if she's talking to me.
Well, you're on the call, right? You have the whole transcript in front of you.
No, you only have the "can I see?"
There you go. Let us know when you want to shift the page 2, page 3. Take your time.
Okay. What page was that message?
9.
Can you go to page 9?
Could somebody highlight it for him?
The court said, "Sir, the question was whether you remember her having said something to you. You said that you did not. And now the question is, do the documents in front of you refresh your recollection as to whether or not she said that? It's not a question of whether or not something is stated in the document. It's a question of whether looking at the document causes you to recollect that she made the statement."
No, not to me.
You were on the call?
Yes.
You recorded the call?
Correct.
You reviewed transcription of those calls and gave corrections to Ms. Murray?
I reviewed the transcripts, yeah.
Made corrections and gave them to Ms. Murray?
What do you mean?
You read the transcription?
Okay.
You made some corrections and you emailed the corrections to Ms. Julie Murray, who is sitting here with the ponytail. Correct?
Ms. Murray said, "Your Honor."
Ms. Shrofa said, "I'm trying to identify."
Ms. Murray said, "I will stipulate I'm wearing a ponytail."
The court said, "The ponytail. Go ahead."
You told her, right, the corrections?
No, these transcripts were not prepared by me.
I never said they were prepared by you, sir. I asked you.
Did I review them? Yes.
You made corrections and you sent them to Ms. Murray, correct? You're on this call, right?
The court said, "Allow him to answer the question. Did you make corrections?"
The witness said, "Corrections on these? Like words or something?"
The court said, "Did you read it and decide that something was correct or incorrect?"
The witness said, "Yes."
The court said, Did you send corrections to Ms. Murray?
The witness said, I don't remember.
Can someone pull up the 3500 material June 6, 2024? Sir, there's a document on the screen for you?
Yes.
Does that refresh your recollection that you in fact sent Ms. Murray changes that you thought were appropriate on the transcription?
Yes.
And you sent them on June 6th of 2024, correct?
Correct.
Going back to the document I was showing you before, which is the April 30th call. Does that refresh your recollection or not?
Ms. Murray said, Your Honor, asked and answered.
The court said, sustained.
You can take that down. In more than one call, Ms. Wang suggested to you to stop receiving funds and close down the Crane account, correct?
Again, it wasn't addressed to me.
Who owned Crane?
On paper, I owned it, yeah. I owned it.
So who else could close down the Crane account?
The messages that she's saying, it's not addressed to me. It's addressed to the other people on the call, Miles' son. She's talking to him directly.
But Miles' son can't close the Crane account, correct?
He can't.
Miles Gua can't close that Crane account, correct?
No.
Only you can close the Crane account, correct?
Correct.
In fact, only you could transfer the money out of the Crane account, correct?
Correct.
All these recordings are because you won't transfer the money, correct?
Not just for that purpose, no.
But one of the purposes is because you won't transfer the money, correct?
One of the purposes, yeah.
Right. And Miles' son couldn't force you to move the money, correct?
Definitely was putting pressure, yeah.
I didn't hear that.
Definitely was putting pressure.
Oh, definitely. We heard about the pressure. My question is...
Ms. Murray said, Objection, Your Honor.
The court said, Don't testify, Ms. Schroff. Don't testify.
Did he get you to move the money? I'm asking about Miles' son now. Yes or no? Did he get you to move the money?
Yes.
You moved the money out of Crane into G Club as Miles' son wanted you to?
Without KYC, I did not, no. Without a package, I did not.
You never moved that money when Miles' son asked you to, correct?
Correct.
He pressured you according to you, and you still never moved the money, correct?
Correct.
According to you, Mr. Gua pressured you, correct? Miles Gua sitting right there?
Yes.
You never moved the money, correct?
Correct.
Ms. Wang pressured you, correct?
Correct.
You never moved the money, correct?
Correct.
William J. pressured you, correct?
Yes.
You never moved the money?
The large sum, no.
Any sum. You never moved the money that they were asking you to move, correct?
The 100 million, no.
Howard he asked you to move the money, correct?
No, that's not correct. Howard he never reached out.
Ana Izquierdo asked you to move the money. You didn't move the money, correct?
Correct.
Now, regardless of whether Ms. Wang made the suggestion or not, you could have always closed the bank account, correct?
Correct.
Best way not to get money into an account is to close an account, correct?
Correct.
Had you closed the Crane account, there would have been no more wire transfers into that account, correct?
Yes, but it had balances.
I didn't ask you about the balances. My question to you was, sir, had you closed the account, you would have received no more wire transfers, correct?
I would have never received wires.
The larger the balance in the Crane account, the larger your 2% fee, correct?
Correct.
Another option presented to you is for you to simply return the money to G Clubs, correct?
Return the money to G Club?
Right.
To send it to yeah, to send it.
Right. That was an option for you. I'm not sure if you're done. I'm confused, sir. I'm asking you?
I'm done.
You didn't do that, correct?
The court said, By that, what are you referring to?
Sending the money to G Club?
Money was sent to G Club.
All the money?
Less expenses, which is a 2%.
You never sent that to G Clubs, correct?
Less money transferred, less money returned. Money was returned to some senders that sent the money. They requested the money to be returned back, so not all the money that came in went to G Club.
How much did you get sued for by the G clubs? What was the dollar amount?
I think it was like for something.
For something?
Yeah, or 3 something. I'm not sure.
3 what?
3 million. I don't have the exact amount.
In the arbitration, how much money were you sued for to return to G clubs?
I don't remember.
56 million?
The initial arbitration, yes.
You had 56 million that you didn't transfer, correct?
Correct.
You were told one option would be to transfer that 56 million to Hamilton. You didn't take that option either, correct?
I don't recall that, no.
You were given the option to transfer the 56 million to Himalaya Exchange. You didn't do that either, correct?
Again, I don't remember that.
One of the other options was not to return the money to the original sender, but to return the money to the person in the middle who had sent the money, and you didn't like that option either, correct?
No, that was not suggested.
And in each one of these recorded calls that you heard yesterday, you kept talking about an escrow agreement, correct?
It was mentioned, yeah, escrow agreement.
You mentioned the escrow agreement, correct?
Could have been mentioned, yeah.
You're not licensed to act as an escrow agent in the state of New York, correct?
We did get a license.
I did not ask you that. I'm asking you if you are registered, sir. On the website at the Department of Finance as an escrow agent?
Yeah, my attorneys did register Crane as an escrow agent, as a money servicing business.
I didn't ask you about a money servicing business, sir. I asked you if you were registered as an escrow agent?
Ms. Murray said, "Objection, Your Honor." Ms. Schroff is arguing with the witness.
The court said, "Sustained." He answered,
Sir, do you think that an escrow agent is the same thing as a money transmitter?
I relied on the attorneys. And they set up a money servicing business license in order to act as an escrow.
Sir, my question to you was, your understanding as a banker of 10 years. Is it your understanding that an escrow agent is the same thing as a money transmitter?
I don't know that.
During the time that you were recording these calls, right? You were at the same time concomitantly trying to work out a PFA with G clubs, right?
That was one of the solutions, yeah.
I could not hear you.
That was one of the solutions that the lawyers and myself came up with.
The court said, "What is PFA?"
Ms. Schrofa said, it's the agreement that he entered into, the payment facilitation agreement.
The court said, "Go ahead."
You hired lawyers so that you could get the agreement, correct?
Correct.
You wanted the agreement, correct?
All parties wanted the agreement.
My question to you, sir, did you want the agreement?
All parties wanted the agreement.
You signed that agreement on May 12th of 2021, correct?
Correct.
And even after you signed that agreement, you refused to transfer the money, correct?
Not before a KYC plus indemnity package was received.
Right. According to you, Crane was going to do KYC even though the bank had already done it?
They were going to verify the indemnity form. It was multiple pages that needed to be completed.
Okay, so it was not KYC, it was the indemnity form?
It was a package.
It was a package. Okay, and at that time you were told, right, that the people who had applied for G Club membership were getting annoyed that they didn't have their membership?
I don't remember that.
You were told by Ana Izquierdo, were you not, that membership could not issue until payment had cleared, correct?
Unless they finish consolidation, yeah. Until Anna and the team of G Club does consolidation.
Well, actually until you release the money. I'll move on. Let me show you what is marked as Defense Exhibit 60539. You recognize this document?
Yes.
What is it?
It's an email.
About what?
Subject line is Notice of Termination.
Termination of what?
Payment Facilitation Agreement.
The same one we've been talking about all this time, right?
The Payment Facilitation Agreement.
The one we've been talking about, correct?
The Payment Facilitation Agreement.
The payment facilitation is between you and G Clubs, right? Crane and G Clubs, correct?
Correct.
And who is Todd Culkin?
Attorney.
For whom?
Crane.
That's you, right?
Yes.
Ms. Shrofa said, Your Honor, we ask that the court allow us to introduce into evidence DX 60539.
Ms. Murray said, just one question to voir dire.
The court said, go ahead.
Ms. Murray said, Mr. Khaled, do you know who asked Limari Reyes to send this notice of termination to you?
The witness said, it's being sent to Alex at G Club.
Ms. Murray said, no objection, Your Honor.
The court said, it is admitted.
Defendant's Exhibit 60539 received in evidence. By Ms. Shrofa.
Whoever it's sent to, it's telling Ukraine's terminated, correct? Ms. Shrofa said, Oh, I'm sorry. May I have the jury also take a look, please?
The court said, go ahead.
By Ms. Shrofa.
May I pose my question, sir? Are you done reading?
Go ahead.
They're terminating the contract with Crane, correct?
Are you talking about the email that's going to Alex?
I cannot hear you.
Are you talking about the email going to Alex?
I'm talking about the notice of termination addressed to the Mr. Todd Culkin at Warren Law Group at 112 West 34th Street, 17th floor, New York, New York, 10120. Your lawyers?
Yes, they're asking to terminate the escrow agreement.
Terminate what?
The escrow agreement.
Well, it's a payment facilitation agreement.
The payment facilitation agreement.
Your lawyers are on the email chain, correct?
From Limori, yes.
And it's addressed to your attorney, correct?
Correct.
And it is dated June 30th, correct?
Yes.
And you read this before, right?
Yes.
They were terminating Crane's agreement with G Club?
Correct.
You can take that down, please. Thank you. Let me show you DX 60540. Let me ask you, sir. While we're waiting for the document to be brought up, did you want the contract with Crane to be terminated?
I'm sorry.
Did you want the contract with Crane to be terminated?
Yes.
You did?
Yeah. At this time, yeah.
Which time?
July, yes.
You wanted it terminated?
Ms. Murray said, objection, asked and answered.
Ms. Shrofa said, I'm simply trying to understand what he's saying, Your Honor. You could instruct him to keep his voice up.
The court said, speak into the microphone, please.
Yes.
Let me ask you to take a look at 60540. If you could just show him page 2, page 3, page 4. And you see there the document is signed?
Yes.
By whom?
Chris Warren.
Who is that?
My attorney.
Your attorney, correct?
Yes.
Ms. Shrofa said, Your Honor, at this time I move 60540 into evidence.
Ms. Murray said, objection, Your Honor, hearsay, relevance.
The court said, sustained.
Ms. Shrofa said, Your Honor, I'll move forward now. May we be heard later at a sidebar?
The court said yes.
Now, your lawyers reached out to the lawyers for G Club and asked them not to terminate the agreement. Correct?
They were working with each other.
I didn't ask you if they were working with each other. My question to you, sir, was, did your lawyer Chris Warren, did you call him Chris or Christopher so I get it right?
Chris.
Did Chris Warren reach out to G Club and say, please, don't terminate the payment facilitation agreement? Correct?
I don't know.
You don't know?
I don't know. They were discussing working with each other.
He's your lawyer, correct?
Yes.
He's working at your say, correct?
Correct.
He's doing what you're asking him to do, correct?
Ms. Murray said, objection, Your Honor.
The court said, don't repeat the question.
Ms. Shrofa said, I'm waiting for a response, Your Honor.
The court said, he answered yes to the question of whether the lawyer was acting at the witness's say.
Ms. Shrofa said, okay. And you through your lawyer asked G Clubs to withdraw their June 30th, 2021 notice of termination, correct?
Correct.
You asked them to work with you so that you could find a way to refund any remuneration, correct?
Again, they were working with each other. The back and forth was a negotiation.
Did the negotiations result in G Clubs not terminating Crane?
No.
G Clubs terminated Crane, period, right?
Correct.
You offered to work with them, correct? Do you recall that?
No.
Well, let's show you 60540 so that will refresh your recollection. Defense exhibit. Let's go to page 3. Does this refresh your recollection that you offered to return the money that was in the Crane account to the G Club account without doing KYC?
Ms. Murray said, "Objection, Your Honor." The question that Ms. Schroff was trying to refresh a recollection on was, you offered to work with them, correct?
The court said, that is correct. The objection is sustained.
Did you offer to work with them by suggesting to them that you would no longer do KYC?
The court said, all right. That question was answered. He said he didn't remember. So the question now is whether or not the document before the witness refreshes his recollection as to whether or not he said that or did that.
Ms. Schroff said, that's where I thought I was, Your Honor. I apologize. But I'm happy to highlight the 4th paragraph on the document. That's not the correct paragraph. It's the benefits paragraph. In an effort to work with them, you suggested certain benefits that would flow from Crane to G Clubs if they kept the contract, correct?
Ms. Murray said, Your Honor, is Ms. Schroff seeking to refresh his recollection on this point? It's not clear.
The court said, is this a refreshing question or a new question?
Ms. Schroff said, it's the same question. I was just trying to highlight it for him. Does that refresh your recollection?
The court said, the question is, does this document help you to remember?
From this document, I remember they wanted the money to be transferred to G Club without anything. Without any KYC, without any information.
They meaning Crane, correct?
No, G Club.
And you also recall, do you not, that your lawyers offered to return all the money to the original senders, correct, from this document?
The court said, the question is, do you recall that, not whether the document says that.
I do recall.
And that was one of the compromises Crane offered to G Club, correct?
To return funds?
Yes.
To the original, yes.
And that was something you had firmly rejected during the recordings, correct?
That's not true.
Okay. In the recordings, that option was suggested to you, and you had never taken it, correct? To return the $56 million back to the owners, correct?
No. There was discussion to return the full amount of G Club money to the owners and close G Club Puerto Rico. That money was for G Club that was at G Club.
But you had not taken that option to return it to the sender, correct?
I didn't have charge of the G Club account.
You had charge of the Crane account?
I had charge of the Crane account, correct.
And the option presented to you was to return the money in the Crane account to the people who had sent it to the Crane account, correct?
Again, that option was for G Club's money.
So you now had, through your lawyer, suggested that keep the payment facilitation agreement with Crane. And we will return the money as you asked before, correct?
As another option, yeah.
They turned you down, correct?
They said they don't want to return the money, no.
They said they didn't want to do business with Crane, correct?
No. This termination is to ask, again, to transfer money to G Club. Whatever is left not cleared to G Club's account. So it wasn't just termination.
It was G Club's telling Crane, we are done. We are not doing business with you, period, correct?
And requesting the money to be transferred to G Club's account.
Exactly.
Without any information.
Exactly. And they were done with you, correct?
Again, they wanted to transfer the money.
Could you hear the question?
Yes, I did.
They were done with you, correct?
Ms. Murray said, objection, Your Honor.
The court said, sustained.
Why did you go to arbitration, by the way?
Why did I go?
Yeah.
I had to.
You had to because G Club wouldn't do business with you anymore, correct?
I had to because G Club was requesting the money, $50 million.
G Club said we're not working with you anymore, period?
'Cause I wasn't transferring the money.
Whatever the reason, sir, they refused to work with you, correct?
Ms. Murray said, asked and answered.
The court said, asked and answered. Move on.
You went to arbitration, correct?
Correct.
You were ordered to return that $56 million back to G-Clubs, correct?
Correct.
You gave all the recordings that you had here to the 3 arbitrators, and they told you to return the $56 million back to G-Club?
Ms. Murray said, objection, compound.
The court said, did you give the recordings to the arbitrator?
The witness said, my lawyers might have, yeah.
The court said, well, answer what you know, not what possibly happened.
The witness said, I don't know.
You went to the arbitration, right?
I did not, no.
You didn't go to the arbitration hearings?
Which one?
Any arbitration hearing.
The first one, no.
You didn't go to the first one at all. Is that your testimony?
The first one?
Yes.
I don't recall, no.
You don't recall or no?
It was a video or a meeting. No, I wasn't.
You didn't go?
I don't think so.
So your company's account was being terminated. You did not go to the arbitration?
My attorneys went.
Right. But you didn't go?
Ms. Murray said, asked and answered.
The court said, sustained.
Ms. Shrofa said, I just want to be clear.
The court said, you asked him whether he went. He answered, move on.
You went to the second proceeding. Is that your testimony?
Yes, I attended that.
And at that proceeding, there was still the same recordings, correct?
Again, I don't remember what recordings they gave them.
Okay. Do you remember any recordings?
Do I remember any recordings?
Yes. Any of the recordings that were here in this trial, do you recall them being part of the arbitration?
Any?
Yes, any.
Maybe 1 or 2, yeah.
Maybe 1 or 2.
The court said, so I don't want you to guess at it. I want you to state what you know.
At least 1, yeah.
You had $56 million plus a 2% fee at stake in the arbitration. Is that fair to say?
Can you repeat your question?
Sure. You had $56 million and a 2% fee at stake in the arbitration, correct?
Correct.
The arbitration could go your way or the arbitration could go G-Club's way, correct?
Correct.
Fair to say you were an interested party in the arbitration?
Not for the 56 million, no.
You were not interested in the $56 million?
Not at all.
Because that's not the amount that would generate the 2% fee. You were not at all interested in that, that's your testimony?
I was not interested in keeping the 56 million, no.
On what money were you earning that 2% fee?
At that point?
I didn't ask you about that point, sir.
Still, I'm talking. At that point.
The court said, please allow him to answer.
Ms. Shrofa said, I think he's misanswering the question. That's my problem. I just want to make sure the question is clear.
The court said, repeat your question.
Ms. Shrofa said, thank you, Your Honor. On what dollar amount is the 2% fee imposed by Crane calculated?
On the cleared amount.
And how much had you cleared?
At that time it was about 97 million.
And that 97 million was cleared from the Crane account, correct?
Correct.
The larger the amount in the Crane account, the larger the amount you clear, correct?
Yeah.
And the larger the amount you clear, the larger your fee, correct?
Correct.
As part of the negotiations that your lawyers, as you put it, discussed with G-Clubs to keep the payment facilitation account, Crane suggested that if the account did not remain in place, you would send the funds to the state of New York's unclaimed fund office, correct?
Might have been mentioned, yeah.
And they still did not keep the payment facilitation agreement with you, correct?
Correct.
Now, it was G-Club that filed the notice of arbitration, correct?
Correct.
There were 3 arbitrators, correct?
I don't recall the exact number.
The arbitrators found no risk of money laundering, correct?
Ms. Murray said, objection, Your Honor. Can we discuss this either at sidebar or perhaps when there's a break for the jury?
The court said, sustained. Fuel approach, please.
Continued on next page. At the sidebar.
Ms. Murray said, Your Honor. The arbitrator's decision is considering information that is not the same as the information at this trial. The severe risk of prejudice in confusing the jury to suggest that any of the findings of the arbitration panel and any of the evidence considered by them in an entirely separate manner would go to in some way the question that I think Ms. Schroff is seeking to introduce it for. Which is to imply that G Club is a legitimate business, and that in fact a judicial panel found that. It's different evidence than this jury is considering. It's extremely prejudicial. It should not come in.
Ms. Schroff said, Your Honor. Isn't that the exact same thing that the government is seeking to do by asking this witness whether or not it was his impression that Ana Izquierdo or Limari Reyes lied during the arbitration proceeding? And that is why the arbitrator found for G clubs. That is literally exactly what they're seeking to do. And I'm simply asking what he understood the arbitrators to find. It is literally exactly the same thing. She's trying to show that the arbitration only resulted in this result because G Club's people lied. I'm trying to show that the arbitrators had more information than just a lie.
The court said, she's not brought up the arbitration. She has not said that the arbitrators made a finding based upon lies stated by those two women. That's not her argument. It's entirely inappropriate for you to try to get out of this witness the legal conclusions of the arbitrators, and so I will not allow that.
Ms. Schroff said, I understand that, Your Honor. It's not a legal conclusion. It's the arbitration award that he as the owner of Crane was told of.
The court said that he was told to pay over a certain amount of money. That's one thing. It's another thing to say that the arbitrators concluded that there was no money laundering. That's completely different.
Ms. Schroff said, it was a finding.
The court said no findings.
Ms. Schroff said, Your Honor, again to go back to what Ms. Murray is going to seek to elicit on redirect is exactly that. She's trying to show that the only, otherwise. What is the relevance of his impression that Ana lied or Limari lied? It is only to show that the lie led the arbitrator to a certain decision. That's the logical conclusion. Otherwise, why is it even relevant?
The court said, the arbitrators considered much more evidence than the testimony of these two witnesses.
Ms. Murray said, Your Honor, in any event, I don't intend to elicit that testimony from Mr. Khaled with respect to those two witnesses, so it's a moot point. And we completely agree that the arbitrator's judicial finding, the decision should not come in. And depending how the questioning goes, we may at the end of the trial ask for a jury instruction to that effect so that they know what weight to give it. If any, but we agree with Your Honor that it should not come in.
The court said, and you're not seeking to elicit testimony about the findings from any other witness, correct?
Ms. Murray said, correct.
The court said, all right, you're not going to go there. We're going to go until noon.
Ms. Schroff said, that's fine. I still have one more question, one more issue. I'm not really clear what the hearsay objection is to the letter sent by Crane to G Club.
The court said, how is it that he can authenticate a letter that he is not the author of?
Ms. Schroff said, he can say I can't authenticate it, but he helped his lawyer prepare it. Their objection was hearsay. Your Honor.
Ms. Murray said, it was several bases.
Mr. Kamraju said, hearsay and relevance to not authenticate.
Ms. Schroff said, this is a document kept in the regular course of business. It is a document sent by a law firm to an entity G Clubs. G Clubs maintains documents in the regular course of business.
The court said, he's not a G Club maintainer of documents.
Ms. Schroff said, sure. But he knows, and of course his lawyer is his agent, that what's good for the goose is good for the gander. The lawyer is his agent, and therefore that document comes in.
Ms. Murray said, agent applies a party-opponent ruling. This is an out-of-court statement. And Your Honors already ruled on the objection. She sustained it.
Ms. Schroff said, I actually did say, Ms. Murray, and the record will show, that I wasn't going to pursue it then. That I would wait until a break cause I didn't want to hold up the proceedings.
Ms. Murray said, I believe you said you wanted to take up the issue again at sidebar. But the judge did sustain the objection on the basis that we raised.
Ms. Schroff said, Judge, I did not want.
The court said, she did reserve argument on the letter, so I just permitted her to do that.
Ms. Murray said, I guess our question would be what the relevance is, and then again we emphasize that it's hearsay.
Mr. Kamraju said, "It's not being offered for the truth, Your Honor. There's no argument that's coming from that letter that says. Because this chart describes the way the PFA is structured, therefore, that is the way the PFA is structured. The entire purpose of offering the letter is to complete the story in response to what happened to the termination notice. This witness just said that he intends that he didn't care about having the contract terminated. His lawyer sent a letter saying, actually, please don't terminate it. In fact, in the letter he says, we intend to keep taking our fee. So there's nothing about it that's being offered to say the facts within it are offered for the truth. And if Your Honor wants to instruct the jury about that, we don't have any objection, but that is the relevance of it. The relevance of it is, they brought up the arbitration in the first place. These are the events leading up to the arbitration. Frankly, I'm hard-pressed to see how it's not relevance if the arbitration is relevant in the first place.
Ms. Shrofa said, "We didn't raise the arbitration. The government did."
Ms. Murray said, just a couple of responses. First of all, it is not his statements. Mr. Kamraju said it's his statements about what Crane intended to do or not. He did not offer the letter. It's an out-of-court statement of a different declarant.
The court said, "Are you not challenging authentication?"
Ms. Murray said, "Of the letter?"
The court said yes.
Ms. Murray said, "There's no foundation for authentication right now."
The court said, "So that is my first question. How does he authenticate a letter from someone else?"
Mr. Kamraju said, if he recognizes it, Your Honor, at the time it was sent, he could authenticate it. That happens all the time, right? Just like you can authenticate a document that you are not the author of if you reviewed it prior to it being sent. We didn't get to that, and maybe if Your Honor wants, we can ask those questions. But we didn't get to that because their objection was hearsay and relevance, neither one of which are relevant. We can try to lay the foundation on authentication, but we didn't understand that was the objection.
Ms. Shrofa said, "It is also kind of surprising that the government would object to the authenticity of a document sent by the Warren Law Group to G Clubs in a document which they received as part of their discovery. Not just from G Clubs, but also from the Warren Law Group."
The court said, "But they're not offering it."
Ms. Murray said, "We're saying this witness cannot authenticate it. He's not copied anywhere on the document or on the forwarding chain above."
Mr. Kamraju said, "We don't know until we ask the question."
The court said, "Then we have the issue of hearsay."
Ms. Shrofa said, "It's not hearsay. We're not offering it for..." I don't want to repeat what Mr. Kamraja said, but I'm happy to have him repeat it.
The court said, "What does the letter say?"
Ms. Shrofa said, "The letter says, please don't terminate us. Can I go grab it?"
The court said, "Yeah."
Ms. Shrofa said, "Thank you."
The court said, "So what does the letter say?"
Mr. Kamraju said, "The letter, I have a copy." The letter basically outlines reasons why G Club should not terminate the PFA, and explains Crane's position. For example, why the PFA does not grant them the ability to terminate. To borrow one of the government's phrases, we're not offering it for the truth. We're in fact offering it for its falsity. Which is a position the government has taken regularly with respect to why something is not hearsay. None of this is something that we're going to say is true. We're not going to say, for example, that this diagram shows the way that the money is going to go. We don't agree that these are benefits to G Clubs. That's a false statement. In our minds, this document has nothing to do with a hearsay purpose. All it is doing is for a non-hearsay purpose of completing the story. Which is something the Second Circuit has repeated over and over again. It's not a hearsay issue. And noting that contrary to what this witness said, he was actually trying to hang on to the PFA so that he could continue to earn millions of dollars in fees. That's the purpose of the introduction of the letter. There's now a single line in here that's being offered for the truth.
Ms. Murray said, "Your Honor, there are exceptions to the hearsay rule. This is a lengthy letter. They're saying both that it's to complete the story and then to impeach him. There's nothing to impeach. He said that his lawyers were engaged with G clubs on these very issues. He said that if more money came into or maintained in the Crane account, his fee would be larger. He said all of that. There's no impeachment from this letter. It's entirely improper to bring this in. Of course they want to argue and bring it in for its truth. Otherwise there is no reason to try to introduce it. I heard no basis for it.
Mr. Khamraju said, he testified that he wanted to hang on to the agreement. I'm sorry. He testified that he did not care about retaining the PFA at this time, specifically in July of 2021.
Ms. Shrofa said, he actually said I wanted to terminate it at this time. And I asked him at what time. And he said he didn't care. He wanted it terminated.
The court said, I just don't recall that testimony. I have to go back to look at the transcript. In the meantime, we'll not deal with the letter. I want a copy of the letter and we'll continue with other questions.
Continued on next page. In open court.
The court said, go ahead.
Ms. Shrofa said, Your Honor, I'm requesting to skip ahead. Mr. Khaled, you testified on direct, did you not? That the recordings that were played here were a random selection by you, correct?
Ms. Murray said, objection, mischaracterizes his testimony.
The court said, sustained.
Your testimony was, there wasn't really a science behind it. It was just random calls that are related to the transfer and request of transfer and what we were doing with this money. Just management calls that I can record. That was your testimony, correct?
Can you repeat the last part?
It was just random calls?
The court said, it's a confusing question because it's not clear whether you're asking whether the recordings played here were randomly selected or whether when he made recordings, he did it randomly. Could you clarify that?
Do you remember testifying yesterday, sir?
Yes.
Do you recall being asked this question and giving this answer? This is yesterday's transcript at 2003. Lines 9 to 13. How, if at all, did you select which calls to record? Answer. There wasn't really a science behind it. It was just random calls that are related to the transfer and request of transfer and what we were doing with this money. Just management calls that I can record. Do you recall being asked that question and giving that answer?
Yes.
And the statement above that these were just random calls is not entirely true, correct?
What do you mean?
You decided which calls to record, correct?
Correct, I decided.
And you decided what calls not to record, correct?
Correct.
You decided when to start the recordings, correct?
Correct.
And you decided when to stop the recording, correct?
Most of the calls stopped when the conversation ended and everybody said goodbye.
Let's look at Government Exhibit 411, and I'm not going to play the whole thing, just the last 20 seconds or so.
Media played.
She's mid-sentence, correct? Anna is?
Yeah.
The recording stops, correct?
It's a glitch.
I'm sorry.
It did not stop. It continued. Is there a pause? I don't know.
Could we play it again for him?
The court said, is there a question as to whether or not the recording ends there?
Ms. Shrofa said, yes. That was my question.
The court said, does the government concede that the recording ended there?
Ms. Murray said, yes, Your Honor. That's the end of the audio recording.
So Anna is mid-sentence, correct?
Correct.
Recording stops, correct?
I guess, yeah.
You're the only one doing the recording, correct?
Correct.
Let's go to Government Exhibit 417. I'm not going to play it, but you recall that conversation. This is the one that you testified to yesterday where you testified that Yvette threw the remote at the TV?
You could play it.
Okay. Do you recall the part of that conversation? I think it's at.
Media played.
You recall this recording?
Yes.
And you recall during this recording, while they're finding the correct portion, you recall Ms. Wang saying that before any money is moved, the issue should be sent to the board, correct? You recall that?
Yeah, in the transcript.
I'm sorry.
In the transcript, yes.
And the transcript is of the recording, correct?
Correct.
And you reviewed that transcript for accuracy because Ms. Murray made sure to ask you to review it, correct?
Ms. Murray said, "Objection, Your Honor. The portion I believe Ms. Shroff is talking about is in Mandarin. And we established that Mr. Khaled doesn't speak Mandarin."
Ms. Shrofa said, "That's not the portion I was asking about."
The court said, "You had been referring to Ms. Wang's statements. Now what are you referring to?"
Ms. Shrofa said, "I'm still referring to Ms. Wang's statements. That is why I don't understand the objection."
The court said, "So statements that were made in English?"
Ms. Shrofa said, "Yes. I'm just trying to point him to where rather than go through the entire recording being replayed."
The court said, "So which statements do you claim were made in English?"
Ms. Wang speaks in English to you, correct, in this call?
In this call, yeah.
And she says, does she not, that the issue should be presented to the board, correct?
Ms. Murray said, "Objection. Can we go to the actual part of the document or the part of the recording that Ms. Shroff is talking about?"
The court said, "Would you direct us to that portion where she allegedly said that?"
Ms. Shrofa said, "Yes, Your Honor. If I could just have a minute." Your Honor, it will take us a minute to find it.
The court said, "Perhaps you could ask other questions."
Do you recall a discussion of Mr. He in this call?
Who are you referring to, Mr. He?
You know a person named Mr. He?
Harren He?
Yes.
I don't believe that he was on this call, no.
Ms. Murray said, "We would object. That portion is in Mandarin."
Ms. Shrofa said, "I have the transcript. It's 417. Do you have the transcript in front of you, sir? Your transcript binder from yesterday, page 22?
The court said, "Of which call?"
Ms. Shrofa said, 417T, page 22.
I'm sorry. I don't have 417 here.
The court said, "At the beginning."
There you go. It's on the screen for you, sir.
The court said, "So you're on page 22?
You see Ms. Wang suggesting that you definitely need to inform board of directors about this. Mr. He saying, you definitely need to inform the board of directors about this, correct?
Ms. Murray said, "Objection, Your Honor."
The court said, "So where is Mr. He on page 22?
Ms. Shrofa said, "Why?"
Ms. Murray said, "That's Mr. William J.E.
By Ms. Shrofa.
William J.E. is speaking.
Totally different people.
That's fine. Sorry. My bad. It's William J.E., correct?
Ms. Murray said, "If I may just note for the record, Your Honor, our objection. Italics indicate Mandarin. That's noted on the first page. We listened to this yesterday. That's consistent. All of the questions that Ms. Shroff is asking about right now are portions that were in Mandarin."
Ms. Shrofa said, "That's correct. That's why I'm asking them through the translation, which is now in evidence at page 22.
The court said, "And the part that you're referring to is Mr. Yu, who is also Mr. J.E. Is that correct?"
By Ms. Shrofa.
William J.E., right? You see that?
I see it.
You were shown exactly this translation and this transcription yesterday, correct?
Correct.
And you have Yvette saying, correct, I have sent you all the G Club company documents. You can find them. It should still, Mr. J himself, it should be himself?
Ms. Murray said, "Objection to the characterization that the witness has that saying anything."
The court said, "So you're saying that Yvette made the statement. Is that right?"
Ms. Shrofa said, "I'm saying what's on the document."
The court said, "So next to the word Yvette we have a statement. That's not the witness's statement. It's Yvette's statement, correct?"
Ms. Shrofa said, "Yes, it's Yvette's statement to Mr. Khaled, who is on the call."
Ms. Murray said, "It's in Mandarin, Your Honor."
The court said, "There are a number of people on the call."
Ms. Shrofa said, "Yes, absolutely. And the document is an evidence stating all the people that are on the call. So if I could go back."
She's talking to me in Mandarin?
Could you go back to page 21? And according to that transcript, because it's in italics, Yvette is speaking in Mandarin according to you, correct?
Ms. Murray said, "Objection to, according to you."
The court said, So the transcript says that words in italics are in Mandarin, so it's according to the transcript.
Okay. It's in Mandarin, correct?
Correct.
And if you keep scrolling to the document, correct? This is the translation of what Yvette is saying on the call, correct?
Correct.
And Yvette is speaking in Chinese, correct? I mean in Mandarin, correct?
Correct.
And she and Mr. Milesgua are speaking, correct?
Yes.
And you're on the call, correct?
Yes.
And according to you, I just want to be clear. You don't understand anything of what is going on during this call that you record?
Ms. Murray said, that's a mischaracterization.
The court said, so do you understand Mandarin?
The witness said, no, Your Honor.
The court said, did you understand when they were speaking Mandarin during the phone call?
The witness said, no, Your Honor.
The court said, please continue.
And after the phone call was over, did you discuss this interaction with anyone?
With Alex?
And other than with Alex, did you discuss it with anyone else?
No.
How about with Ms. Wang?
No.
And you've now reviewed in preparation for your testimony here the translation of this recording, correct?
Correct.
And in the translation, there's no indication that Milesgua says during this call there is no reason to go to the board, correct?
Ms. Murray said, objection, speaks for itself.
The court said, sustained as to what it does not say. Are you asking the witness to review the entire transcript to search whether Mr. Gua made a certain statement or did not?
Ms. Shrofa said, yes, I believe I am, actually. And I think he's reviewed this transcript several times.
The court said, well, we'd have to give him an opportunity now to review unless he has a recollection. Do you have a recollection of whether Mr. Gua made that statement?
The witness said, no.
Ms. Shrofa said, I'm happy to come back to that question after the lunch break. And perhaps the witness can review it through his lunch break.
The court said, no, the witness is not required to review documents during the lunch break.
Ms. Shrofa said, I said perhaps. I'm happy to wait here. It's up to the court.
The court said, so is it your testimony that you do not recall whether Mr. Gua made the statement?
The witness said, I don't.
The court said, you do not. Go ahead.
By Ms. Shrofa.
After this call, do you know if William J.'s suggestion was in fact followed?
No.
Do you know if Yvette Wang's solution to go to the board was in fact followed?
Again, no.
You'd agree with me, would you not, that this was quite a tumultuous conversation, correct?
What do you mean by that?
It was a heated conversation, correct?
At the end, yeah.
And there were parts of it that you didn't understand, correct?
Correct.
It involved you as well? The conversation involved you, correct?
Not pertaining to G Club, no.
Were you a disinterested party in the conversation?
Yeah, they were discussing G Clubs, transfers on G Club's accounts.
Did that involve you?
No.
So then why did you remain on the call?
They asked me to get on the call.
And why did you record it if it didn't involve you?
I was in it. I didn't know what's going to be discussed.
Okay. You didn't know what was going to be discussed, but you nevertheless recorded it?
Yes.
And after you recorded it, you had no curiosity to find out what was said?
No.
Now, yesterday you testified, right, about your first week at Saraca, remember that?
Yes.
And you testified that was during the pandemic? You started during the pandemic, correct?
Correct.
And you also testified that there were very few people at the East 64th Street office, correct?
Correct.
And at that same time you were still working for Citibank, correct?
Correct.
And you had an online presence for both jobs, correct?
I had what?
You had an online presence for both jobs, correct?
What do you mean by that?
Well, you had to go to work at Citibank through Zoom, correct?
No, my job description was not like that.
Well, I'm only asking because it was the pandemic, sir.
I understand, but that wasn't online presence. That wasn't required, no.
What was Citibank expecting you to do for the 7 hours you worked for them?
During that time we were dealing with the PPP.
For Citibank?
For Citibank, yeah. We were trying to help small businesses get their money for the pandemic. So all hands on deck was for that.
Okay, but that was your job, correct?
Yes.
And that was until October 30th when you resigned, correct?
October 1st I think I resigned.
Well, are you sure it's October 1st?
I'm not really sure it's October 1st. I think it's in the beginning of October.
Did you review that fact with Ms. Murray when you met with her?
I don't remember.
You don't remember the day you resigned of your job of 4 years?
Ms. Murray said, asked and answered, Your Honor.
The court said, sustained.
To work at Citibank, you have to log in, correct?
Not necessarily.
How do you access an account without logging in?
Again, I was on the relationship side, so my job required me to speak to customers.
Send emails?
Yes.
To send an email, do you have to log into the Citibank network?
Correct.
You can't use your Gmail to do Citibank work, right?
You could send an email from the phone.
You could send an email through the phone, that is true, but only through your Citibank email account. Correct?
Correct.
So you had to log into your Citibank accounts, correct?
Yes.
And it's fair to say, right, for the time you were double billing, so to speak. You didn't want a Citibank to find out you were working at Saraca, correct?
No.
That's not fair to say?
I didn't want them to find out.
So you had to juggle 2 employers at the same time, correct?
Correct.
So on the days that you went to East 64th Street, how did you do Citibank work?
On the phone and on the laptop.
On whose phone?
My phone.
Which phone?
My phone.
Was that your personal phone? Was that the phone given by Citibank? Or was that the phone given to you by Saraca?
No, there's an app that is for the Citibank email on my personal phone.
So you used the Citibank app to take Citibank calls?
Emails, like emails. What specific is your question?
My question is what happened when a Citibank client called you. How did you handle that?
I would answer.
What happens if you were in a meeting with Mr. Gov't or with Ms. Wang or with Alex H?
I would call back.
You would call back?
Yeah.
So you made judgment calls as to which was more important, the Citibank question or the Saraca question.
Can you repeat the question?
Sure. If a Citibank client called you while you were in the middle of a Saraca meeting, how did you prioritize?
If I'm in a meeting, I would call back the client.
And if you were on a call with a Citibank client and Yvette Wong called you or Miles Guo called you, you would prioritize Citibank, finish the call, and then go to Miles Guo?
Might have, yeah.
You just don't know, correct?
It depends.
And you kept no timesheets, right, for Citibank?
I wasn't required to.
I understand. But you were doing 2 jobs all at the same time, right?
Correct, but there was no time sheets. There's no requirements of certain time I have to report and leave in either work.
Right. There were no requirements on you at all, right? That's why you were able to do this. Charge 2 people at the same time?
Ms. Murray said, Objection.
The court said, overruled. You can answer.
So, again, I didn't have a timesheet for both. So there wasn't a requirement of 40 hours at a certain job and 40 hours at a certain job from 9 to 5 or that schedule. So there was no timesheet if that's what you're asking.
Ms. Strofa said, Your Honor, that wasn't my question.
The court said, there was a 2-part question about whether there were any requirements, and then there was a question about whether he could double bill.
Ms. Strofa said, Right.
The court said, so he's answered whether there were requirements, so now you can answer whether you could double bill.
By Ms. Schrofa.
Because there were no time requirements?
I wasn't billing. It's not a bill. It's wage.
You're cashing a check, right?
Yes.
For what?
For work.
Right. So I'm asking you, how you did 14 hours of work in a 7-day day?
Like I said, it wasn't hourly, so I fulfilled both jobs' requirements. I attended all my meetings that needed to be attended when I was requested.
You attended all of your meetings. So if Citibank had a meeting at the same time Saraca had a meeting, you attended both meetings?
Ms. Murray said, Objection. That's not his testimony.
The court said, you can answer.
It never happened where there's two meetings at the same time.
Now, when you resigned from Citibank, you were terminated pending an investigation, correct?
I resigned. Resigning is before. You can't be terminated after resigning. I don't understand you.
Well, you resigned, correct?
Okay.
Citibank had to accept your resignation, correct?
Correct.
Citibank had to decide whether if you were resigning in good standing, correct?
I don't know that.
Well, they had to decide whether to give you your pension at Citibank, correct? Let me ask you this way. If Citibank found out that you had been working on the side for a company that Citibank had closed its accounts, do you think Citibank would have given you your pension?
Ms. Murray said, "Objection, Your Honor. Calls for speculation, no personal knowledge."
The court said, sustained.
Citibank has a policy, right, after a person resigns to either accept or not accept a resignation.
I wouldn't know that.
You wouldn't know that?
No, I don't.
How did you resign?
I sent an email to my manager sent an email to my manager.
You sent an email to your manager, and did Citibank respond?
Yeah.
Do you recall if they told you that you were terminated pending an investigation?
No.
You don't recall?
No.
Sir, did you have an exit interview with Citibank?
I don't recall.
Do you recall ever disclosing to Citibank that while you were working at Citibank you were also working at Saraca?
No.
The court said, one moment please.
Pause.
The court said, go ahead.
Now, you testified on direct, right, that in your first week at Saraca, you were tackling the issue with Citibank and trying to find an account for Saraca and GTV, correct?
Correct.
And what do you mean when you say tackling the issue with Citibank?
I was still trying to find out what's the status of the account and how Gov't is going to receive the checks of the balance that was stuck at Citibank.
At Citi, correct?
Correct.
And who at Citi were you dealing with then?
James Song.
Continued on next page. By Ms. Shrofa.
James Song, correct? So James Song was a colleague of yours, correct?
Yes.
And did James Song understand that you were calling him as an employee of Saraca, or did he think you were trying to resolve the issue of these bank accounts as an employee of Citibank?
So.
Ms. Murray said, "Objection, Your Honor."
The court said, you can answer.
So when I started in August.
Started where?
At Saraca, the accounts were already closed.
Okay.
So what I meant tackling the issue of Citibank is receiving the checks and opening up a new account for them.
Okay. So you are now no longer talking to James Song, as you said a minute ago.
Not in regards to the account, no.
Okay. So let me just go back to your testimony from yesterday, okay? You said you were tackling the issue with Citibank. Could you tell me with whom at Citibank you were tackling this issue?
So I was dealing with Aaron to make sure that we received smaller checks or...
Who's Aaron?
Aaron Mitchell, the...
Aaron Mitchell is not at Citibank.
Yeah, correct.
Right. My question to you is...
Ms. Murray said, "Objection. It mischaracterizes his testimony."
The court said, so allow him to finish. You were saying.
So I was getting checks from Aaron. And these are the Citibank proceeds of the checks that was blocked. That's what I meant.
You said tackling the issue with Citibank, correct?
The court said, what did you mean by that when you said tackling the issue with Citibank?
The witness said, "The money that was now blocked at Citibank and closed, and they have checks in place. I believe the checks were issued before August 1st.
The checks were still with Citibank?
I don't remember.
The money was still with Citibank?
I really don't remember. I don't remember, no.
You don't remember.
No.
Ms. Murray said, "Objection, Your Honor." Asked and answered.
The court said, sustained.
And were you attending meetings with people at Citibank to get those checks cleared?
No.
Did you have phone calls with Citibank about getting those checks cleared?
No.
Didn't Ms. Wang tell you, call your old bank and ask them why these checks aren't cleared? You used to work there, correct?
That's it again. That's before August 1st.
Before August 1st or not, when Ms. Wang told you that?
No, it's a big.
She was under the assumption that you had left Citibank, correct?
No.
She thought you were still working at Citibank?
She knew I was still working at Citibank, yeah. Can I see the text dates? Do you have dates?
What was your first week at Saraca? What was your first week? What was the date?
I believe August 1st.
So, August 1st, you had told Ms. Wang that you were doing 2 jobs. That's your testimony today?
So she asked me if I had resigned in July, when I accepted the offer. And when I could start. She asked me to start as soon as possible.
Ms. Shrofa said, I move to strike.
The court said, sustained.
Okay. So what's your question again?
Ms. Shrofa said, could you read him the question back, please?
Record read.
No. August 1st, I didn't tell her, no.
Okay. So in your first week, Ms. Wang is talking to you about the blocked checks at Citibank, correct?
She was asking me to find another bank, yeah.
She was asking you about the blocked checks, correct?
I don't recall.
How much money was in those checks blocked by Citibank?
200 million.
She wanted that 200 million unblocked. Is that fair to say?
Ms. Murray said, objection, Your Honor.
The court said, you can answer that question.
I'm sure she did, yeah.
And isn't the whole point of hiring an ex-Citibank employee so that they can help figure out how to block the 2 million being kept by Citibank?
Ms. Murray said, objection, Your Honor.
The court said, sustained.
You were hired for your experience at Citibank, right?
Ms. Murray said, objection, Your Honor. He doesn't know.
The court said, sustained.
Did you make any effort to get those $2 million back from Citibank?
I wasn't in charge of that. All I did was get updates from John, from James.
You got updates. And when you got those updates, did you tell him, hey, buddy, I'm working at Saraca now. Let's have a drink?
I don't remember.
I'm sorry. I misspoke. It wasn't 2 million, it was 200 million that was with Citibank, right?
I believe so, yeah, it was 200 million.
Now you just testified that you were trying to find other banks. Is that what you testified to? I don't want to get it wrong. You tell me. What else were you doing during your first week?
Getting situated, email, figuring out the phone, payroll, and one of the things was they needed a new bank account.
Well, you weren't doing payroll, right?
I'm sorry?
You weren't doing payroll there, right?
No, setting up my payroll so I could get paid.
Okay, so that took the whole week, or is that part of the week?
I don't remember exactly. No.
Okay, and you were trying to look for other banks now, correct?
Correct.
Okay, and G Clubs, you remember it had launched in October of 2020, correct?
Correct.
And you wanted to find different banks for G Clubs to do business, is that fair?
No.
And you tell me. Which banks did you contact?
So I was trying to open an account for Saraca and GTV.
Right. But where?
I believe that Bank of Princeton and Signature.
Well, how did you identify the Bank of Princeton and Signature?
What do you mean?
I'm sorry?
What do you mean?
Well, there are many banks, right? How did you land on Bank of Princeton and Signature Bank?
I had contacts.
Okay.
In both banks.
Okay. So you reached out to your contacts, correct?
Correct.
And you reached out to your contacts through your GTV or Saraca email address, correct?
Or personal. I'm not sure.
Okay. And then you talked to people at Bank of Princeton and at Signature Bank, correct?
Correct.
And this was in August, correct?
I believe so, yeah.
Well, that's your first week there, right?
August, yeah, was my first week.
Right. So when you were talking to Bank of Princeton and telling them you wanted to open these bank accounts, you put yourself out there as a Saraca employee, correct?
I might have, yeah.
You might have?
Yeah, I don't remember how I started the email, or message, or whatever.
So sitting here today, you don't know if you told Bank of Princeton, hey, I'm working at Citibank. I'm trying to have this client Saraca open a bank account at Bank of Princeton, or whether you told Bank of Princeton. I now work for Saraca. I want to open a bank account with you.
Ms. Murray said, objection. Asked and answered.
Ms. Shrofa said, I don't think I asked any question about Bank of Princeton.
The court said, did you hold yourself out as being employed by one entity or another?
The witness said, I don't recall, in that.
The court said, all righty. We're going to stop at this time for our lunch. You'll return at 12:30. Remember not to discuss the case amongst yourselves or with anyone else. Don't permit anyone to discuss the case in your presence. But I also want you to consider the proposal that I made for the 4 days of next week. Wednesday you're off, and I'm asking whether you can come in at 9:30 and go until 1 o'clock, with a full hour break until 2, and then to go from 2 to 5. And don't watch, listen, or read anything about anything having to do with this case.
Continued on next page. Jury not present.
The court said, sir, you may step out. Don't discuss your testimony.
Witness not present.
The court said, I'd like to get a copy of the letter in question.
Mr. Kamraju said, I have it here, Your Honor. I'm just going to hand it up.
The court said, please be seated. It is the contention of the defense that this letter dated July 11, 2021, from Warren Law Group to Limari Reyes Molinares is not being offered for the truth of the matter asserted. Is that your position?
Ms. Shrofa said, yes, Your Honor.
The court said, and your position is that it's being offered for what purpose?
Ms. Shrofa said, Your Honor. I'm going to let Mr. Kamraju handle this because I stepped out from the sidebar, so I don't want to repeat. If that's okay with the court.
Mr. Kamraju said, the letter is being offered for 2 purposes, Your Honor. One is to complete the narrative with respect to the events that lead up to the arbitration, which the government elicited, and second, to impeach the witness's testimony that he claimed that he did not want to remain in the PFA as of this time.
The court said, does the government wish to add anything?
Ms. Murray said, yes, Your Honor. On the point of completing the narrative. You can't just say that something completes the narrative to get it in. And to establish that this completes the narrative is offering it for its truth, it simply is. Which is not permissible. And separately, with respect to the alleged impeachment. The witness did not deny that the letter says what it says. He also didn't deny that his counsel was engaged in discussions regarding a PFA. There's simply nothing in this letter, which the witness did not write and which he was not copied on. Did not receive, that goes to anything that he said on the stand, and certainly doesn't impeach anything he said.
The court said, so I understand the defense to be saying that he said during testimony, I don't recall this, that he was not interested in the PFA continuing at the time that this letter was written. Am I correct?
Mr. Kamraju said, that is my recollection of the testimony, Judge, yes.
Ms. Shrofa said, Your Honor.
Ms. Murray said, this is.
Mr. Kamraju said, also, sorry.
Ms. Murray said, this is about issues that his counsel had about what was going on with effectively a contract dispute. It's not the question that they posed to the witness, which was what he wanted or didn't want. He answered that question. This is an entirely separate thing that relates to legal negotiations between 2 parties.
Ms. Shrofa said, Your Honor. Ms. Sharonda has agreed to look at her transcript and give me the page number during the lunch break. I'd be happy to send an email to the court and copy the government on it.
The court said, and you're claiming that this statement was made by the witness when?
Ms. Shrofa said, I think he testified to it this morning.
The court said, this morning?
Mr. Kamraju said, it was this morning, Your Honor. This is the first time the letter came up was this morning. Through Ms. Shroff's cross. He said that he was, at that point he wanted to get out of the PFA. Which is the legal contract that is being discussed in this letter, not some distinct contract. Ms. Shroff asked him specifically at this time, I'm paraphrasing the question, we'll have the transcript. But, at this time, and he said July 2021, which is the period of the letter. He also testified that the lawyers were acting at his direction. In fact, he testified to that I believe in response to Ms. Shroff's question and I believe the court's question.
The court said, so it's your position that the letter contradicts his statement because it indicates a desire on his part to continue with the PFA.
Mr. Kamraju said, yes, Your Honor.
Ms. Murray said, and Your Honor, it's not his statement. He made a statement when he was testifying. That's his statement about what he wanted or didn't want. This is a legal negotiation as reflected in a document between two parties. He's not a party to it. If it were proper impeachment, they wouldn't have to say that it's being offered to complete the narrative. The fact that they're saying it's offered to complete the narrative of the timeline of what's happening in the negotiations regarding the PFA is offering it for its truth. It is not permissible.
The court said, and why do you think they're offering it for its truth?
Ms. Murray said, because they're trying to back this document into the case, Your Honor. So they can use it for other purposes.
The court said, what other purposes do you think they want to use it for?
Ms. Murray said, I don't know. I anticipate that they want to use it in their argument at closing. I think they're going to point to different aspects of this document, including different statements that it makes about G clubs and G clubs operations, the benefits to G clubs of the PFA, either continuing the PFA or canceling it.
Mr. Kamraju said, no, Your Honor.
The court said, so exactly what portions of the letter do you want to come out, and for what specific purpose?
Mr. Kamraju said, we want the letter to come out to say your lawyers responded to the termination notice with this letter. And the letter indicated that you, Crane, his company, wanted to remain in the PFA at the time of July 2021. We don't agree that any of the contentions in that letter are true.
The court said, so is there a portion of the letter which expresses the desire of Crane to remain in the PFA?
Mr. Kamraju said, well, yeah. For example, Your Honor, I think even the benefits to G clubs from remaining in the PFA. We don't think that those are true, but we think that's an attempt to convince G clubs to remain in the PFA.
Ms. Murray said, that's a matter of interpretation.
Mr. Kamraju said, which the jury can do.
Ms. Murray said, they're not answering the court's question.
The court said, these lawyers are very capable of stating whether or not they're urging the other side to cancel the agreement.
Mr. Kamraju said, yes, Your Honor, and I think if Your Honor looks at the letter, it is very apparent that these skilled lawyers directly were trying to entice G clubs not to terminate the agreement. That's the entire purpose of the letter, is a response to the termination notice. It is not a response that says, yes, we agree to be terminated. It is a response that says, do not terminate this for X, Y, and Z reasons. We are not going to argue to the jury that X, Y, and Z reasons were accurate, in fact. That's the opposite of our argument. It's for the same reason, when the government says, we're putting in this document for the falsity of it, that's not hearsay, it's the same concept.
Ms. Murray said, it's simply not impeachment, Your Honor. You asked Mr. Kamraju which portion of the letter he was going to point to impeach the witness, and he responded with two statements or two facts that he was seeking to elicit as supposed impeachment. And first of all, he can ask those questions without reference to this letter, without seeking to introduce this 4-page letter. And in any event, the sections that he's pointing to or the paragraph he's pointing to is not proper impeachment. There's no basis for impeachment. This witness has not denied anything that's reflected in the letter. And even if he did, this is not the way to impeach him.
The court said, all righty. I'm going to look at the letter. We'll come back at 12:30.
Ms. Murray said, and Your Honor, just for timing purposes, it's been 2.5 hours so far on cross this morning. I would just ask how much longer Ms. Schroff has.
The court said, Ms. Schroff?
Mr. Horton said, well, Your Honor, I'm going to play the video that one of the calls, because they want the call played. I don't know. Honestly, I'm a little discombobulated. I don't know. Maybe an hour?
The court said, so I want you to be efficient in your asking of the questions. We'll meet again at 12:30.
Luncheon recess.